We'll wait. Oh, we're live. Okay. So it is Thursday, March 16th, and Senate Economic Development, Housing and General Affairs. We're taking up S-103 related to prohibitions against discrimination in the workplace. And we're starting with Rich Cassidy. Morning, Rich. The floor is yours.
Good morning, Senator, members of the committee. Thank you very much for giving me the opportunity to talk about S-103. I practiced law in Vermont since I finished clerking for the Vermont Supreme Court back in 1980, which happens to be the year when Chief Justice Al Barney wrote the first ever decision interpreting FEPA. So I've had the opportunity to watch the law develop and see its effects on the ground all that time. Counseling and advocating for employees has been the largest part of my practice for 35 years. Now I'm beginning to transition my practice to work as a mediator and arbitrator. I'm delighted that you've taken up three really critical issues in this bill and S-102, just cause employment termination, covenants not to compete, and the elimination of the severe and pervasive impact requirement from harassment law. More about those issues on another day, but I want to applaud you just for taking them up. My remarks this morning are about a single provision of S-103, the proposed addition to Section 495J to the Fair Employment Practices Act. That section prohibits what are called in the business "do not darken my door" provisions in agreements settling the discrimination cases. As I read it, this language would make agreements calling for an employee to resign or to promise not to reapply for work with an employer unenforceable as conditions of settlements. I know that the proponents of this subsection believe it will help employees. Overall, I believe it will hurt them. Litigation is a dispute resolution process. Well over 90% of all civil lawsuits are resolved by settlement. The statistics, if they were available to us in employment discrimination cases, would be much higher. Most litigants want peace. They want an end to the enormous trouble, pain, expense, and distraction of a lawsuit or even of a claim. If this section becomes law, every discrimination litigant trying to get a case resolved by agreement will pay a price in a reduced settlement value. From my work as a mediator, I know that if employers can't be guaranteed that settlement will bring an end to a fraught relationship, they simply won't pay as much money to resolve cases if they are willing to settle at all. Who are these discrimination litigants who will have to settle their cases for less money if they can settle at all? Many of them are exhausted emotionally and financially by the gauntlet that is this process. Some of them are harassment victims who are still working for the employers at which they were harassed. Some of them want to get out of their employment if they can settle. Many of them have been through the Civil Rights Division investigation process. They've often waited 2 and sometimes 3 years for a non-binding investigation to be completed by overworked Civil Rights Unit investigators and lawyers. If they've been fortunate enough to find private counsel, they may be at some point in the discovery process, motion practice, or even on the list for trial. Or perhaps they're waiting for another year or 2 after summary judgment has been granted to the employer for an appeal to be resolved, hoping to get back in line for a trial. Proof in discrimination cases is very difficult. Few cases are based on direct evidence of discrimination. Most cases are based on circumstantial evidence. We must prove intention by inference from the surrounding facts and circumstances. Without direct evidence of motive, which we very rarely have, we are trying to prove what electrical impulse went through the brain of the decision maker at the moment of an employment decision and motivated an adverse job action. Some few will be successful if they can fight through the process. Some are truly victims of discrimination whose cases simply can't be proved. Some believe they've been discriminated against when they have not. I know there is the view that this section will help people because it will prevent them from being retaliated against by needing to resign to settle or being barred from seeking employment after a settlement. Perhaps it will help a few, but it will do so at the expense of the rest. I urge you to delete subsection J from this bill. I don't ask you to do this for employers. I ask you to do it on behalf of victims for whom some measure of justice is better than none. Thank you. That's my testimony this morning.
So Rich, any questions? Rich, oh,
I do.
Yeah.
I was just, but did you have a question?
Yeah. I mean, you know, we've had this conversation before, just when we voted on this bill last biennium. You talked a lot about how someone could be under duress and just emotionally exhausted. And when you're emotionally exhausted, it might feel like, fine, you know, let me just give up my right to ever work at the hospital again, or the university, or a really big institution, because you just want things to be over. And then 10 years later, you know, that decision really comes back to haunt you, because we're a state that has many tiny employers and just a few very large employers that, you know, employ huge chunks of the state. So I just wanted to say that and see if you have a response. I mean, this idea that someone's emotionally exhausted almost to me seems like it's not a good time when someone could put something on the table that, you know, they might agree to that has very, very long-term consequences.
It's not a good time, Senator. But you know, the reality is, if you look back at FEPA as it was adopted back in the early 70s, I guess it was, it had a provision for reinstatement. It still has that provision. A judge can order an employee who's been the victim of discrimination reinstated if the employee wins their case. I've never seen that happen in Vermont. I've rarely heard of it happen. It's also in Title VII. I've rarely heard of it happen nationwide. There's a reason for that. If someone goes through this exhausting process, the employment relationship is mostly irretrievably broken. It's not going to be successfully resumed. I've had 2 or 3 instances in 35 years when I have been able to negotiate an arrangement for reinstatement. It's very rare. A few times when I've been able to negotiate an arrangement to allow an employee to stay. Those cases have one thing in common. They're cases in which a lower level person was the discriminator or the harasser. And when the boss heard about it, when the top level heard about it, they were really angry and they wanted to do the right thing. That can happen, and it does happen, but it happens so very rarely because it's human to see the world through your own point of view. And the employers typically feel as righteous in their position as the employees, even when they're wrong. So I just don't think it will work as a practical matter.
Thank you. Do other states do this? And do you have any suggestions for some middle language, like 5 years, you know, when the employee wouldn't return?
I believe California has a provision like this. I would say that the culture in California is pretty difficult around it, pretty different around employment litigation than Vermont. Very different, really. It's the most employee-friendly place in the country, and I'm appreciative of that. They seem to make it work. I admit that. I don't know the details of at what cost. I don't think there's an easy middle ground. I think making it clear that an employee can enforceably resign as a condition of making a deal if the employee is still employed would help. I think a waiting period would really help. You know, valuable employees may be able to come back after a period of time when management changes and things are different. I've seen that happen from time to time. And I wouldn't feel as strongly about it if there were a 5-year waiting period. But the idea that it prevents resignation from being effective is just a nightmare for settling cases.
Any other questions for Rich? Well, thanks so much for your time this morning, Rich.
Thank you.
We appreciate it. We appreciate you always being able to comment on employment law matters. So thank you.
Well, you're so very welcome. And as I say, I think the committee is embarked on really important work here, and I'd love to share with you some of my knowledge and some other of the subject matters that I hope you'll be taking up maybe after crossover day. I appreciate
Yes,
it.
that's right.
Okay.
Yes, thank you so much.
Bye now.
Megan.
Good morning. Megan Sullivan, Vice President of
No, I was trying to get anything out of your way, sorry.
Vice President of Government Affairs for the Vermont Chamber of Commerce. Thank you for making time to have me back this morning and for coming in early to hear from us.
Don't remind us.
I know, sorry. I appreciate the committee listening to thoughts on 102 yesterday, and going to talk about 103, but also sort of, as we continue our work at the chamber on the cumulative impact, maybe some areas where I see the intersection of 102 and 103 being challenging, especially challenging.
The intersection.
Yeah.
They apply together.
So, just quickly on the rehire provision, I think this is of concern both from the employee and the employer side, and that is a provision used to reach a settlement. It typically means that the settlement is a higher dollar figure, and removing it will likely just lead to further lawsuits if that employee reapplies down the line and it's not provided the job, that it will be seen as retaliation, even if there's other reasons. So we have concerns there. We know that sort of both sides of in the situation have concerns, but that's sort of where we are on that. We have also concerns around the removal of the severe and pervasive standard, especially as there's an expansion of the definition in harassment. I think, we've been working to attract a more diverse workforce to Vermont. And so it's really important as that work is happening that we bring attention to what are our laws around harassment and discrimination, to see where there needs to be updates to make sure that people are protected. By removing this federal standard of severe and pervasive, we are worried about
I didn't realize we were removing.
Well, we're removing.
Oh, we're
bar,
removing, right.
And it is supposed to be severe or pervasive.
Severe
as I
or
understand it.
pervasive.
which is
And it's being
Yeah.
treated like severe and
Yeah.
pervasive,
Right.
which already is the problem.
Right.
that,
And then
and that
we're
we would agree
reducing
that
the bar.
that if it's being treated as severe and pervasive, that is a problem. And if there's a way to clarify that it should be interpreted as severe or pervasive, we are certainly supportive of that. If there's a way in statute to make that very clear for the courts that is the standard. But this, by removing that bar, I think a lot of the employers that we're working with have been doing a lot of important work around training for their employees on harassment, creating internal procedures to deal with discrimination and harassment, and that sort of those good players that are doing that are going to be faced with lawsuits where something that is not severe or pervasive would lead to lawsuits, when there could be an internal process that is an important opportunity for counseling, discipline, or even in some cases termination if necessary. So we would like to see that standard remain in place and further clarified if there's issues with severe and pervasive getting mixed up with severe or pervasive. I think if we're changing the bar to something that a reasonable person would not find trivial, that's challenging. And so when we talk about that cumulative impact, so in 102, we're saying an employer can't stop you from expressing.
It's an employee with the same protected characteristic, which I do think is a little different, that they would not find trivial. Because if you are someone with, you know, a different identity and
Right.
you find it
So here's my
trivial.
example. So you have an employee who says, you know, the employee handbook says you can't wear anything that's offensive. Well, under 102, we're now saying you can wear something that expresses your freedom of speech. And maybe that is something that people don't find trivial or, you know, that is above trivial, but offends women. I think we've all been to a fair where there are shirts that are offensive to race, gender, sexual identity. And multiple people say, well, that's not trivially offensive, that is offensive. Now, the employer can tell that person, you can't wear that shirt because they're expressing their freedom of speech in the workplace.
Julio will want to address that.
Sure. And
I wasn't here for that conversation yesterday where these are merging now.
well, you know, we're sort of trying to think, I think it's important to think through like how, when we're talking about one piece of the law and another piece of the law, how
What would
How
their
will they-
protected characteristic be that allows them to wear that shirt that's offensive to women?
in 102, it's a protected characteristic. I don't,
No, but if
No,
you're
it's
saying
not.
now they would face harassment for wearing a shirt.
no, the people who are visually seeing that
Okay.
shirt under, you know, that it's harassment is now visual. So as a woman in the workplace, I'm seeing someone wear a shirt that I find offensive and that my colleague finds offensive.
Right.
Then we're
I
saying
agree
that
with
is not
that.
trivially offensive, that offends me. We're gonna file suit.
Mhm.
Now, as an employer, they can't stop somebody from wearing that shirt, but at the same time, now they're facing a lawsuit from someone, from people who feel offended by that shirt.
So you're saying this is double bind for,
If the hands are tied.
I mean, let's use a real world example, like maybe this is a real world example,
Right.
but you know, we've had, City of Burlington had an issue with somebody who drove their car into the parking lot with a Confederate flag every day. And, you know,
Right.
that their speech was already protected, driving their pickup with a Confederate flag into the parking lot and leaving it there. They were not allowed to bring the Confederate flag inside the building, but that already exists where, you know, nobody could, I don't know how they would bring a claim that they're being specifically harassed.
But she's saying now they can wear a Confederate flag on their T-shirt inside the building.
with 102, that their expression of free speech
Right,
can be construed through their clothing. Because we're not constraining, you know,
right.
we
Okay.
talked about that yesterday. I think that's what you're saying is,
Yes.
and that then could be
But this is,
subject for a suit
Okay.
for somebody who
I don't
feels
know
that's
if that's
harassed.
true. I don't know if
And
they can
at
now
this
wear a
point-
Confederate flag into the building.
The only people that aren't protected essentially are white males. What if a female wears a T-shirt or something that says some pretty raunchy, bad, offensive things about men? Does the man have the ability to say, I find that harassing and offensive?
I think we should ask that with a lawyer in the
Yes,
chair. We're
I think
talking about
they do.
protected characteristics, not protected people.
No, race and gender are protected characteristics,
Yeah. But is it all gender?
or only certain
Yes,
gender.
it is. No, if they're,
Oh,
that's not true. If they are targeting someone based on a protected characteristic, that's different than they're excluded because they're a white man. If you are attacking men over and over and over again, I think we'll hear from a lawyer that that's a characteristic that you can't attack. Is someone based on their gender.
But I think as it currently stands, an employer could say that shirt does not fit our
It's not appropriate.
our
for the
workplace standard of wear, and you can't wear that. As you said, you can't bring the flag into the place of work, but you can fly it on your truck. Or if they do, an employer could go through, you know, either saying that in a disciplinary action, as well as saying, and you need to go through, whether it's, you know, DEI counseling, training, you need to go through harassment training. And again, are we going to run into a situation where the employee says, I'm not going to do that because you're expressing a political opinion and my rights now say I don't have to go to a meeting where political opinions are expressed.
Which was her testimony yesterday, which was one of your examples.
Yeah, and
Being challenged.
you know, again, we're just leading to sue the employer for, one thing or another. It just feels like we're opening up a lot of lawsuits where an employer has no opportunity for that internal work to be done to say, how can we rectify the situation? How can we do restorative justice within our office to make things better? And I think we have similar concerns when it comes to public accommodation. The first thing I thought of was a restaurant this summer where an owner said, we don't allow pets. And the patron said, this isn't a pet, this is a service animal. Said, we don't allow animals in our restaurant. You can't be here with your animal. And it really caught the attention of the media, it caught it on social media, and it led to a really deep conversation in the community about disability rights, and led to important training for that restaurant owner and for a lot of restaurants in the state about how do we interact with disability rights. And I think it was an important opportunity for growth and conversation that, under this could have led to a lawsuit that closed the business rather than that opportunity for growth.
Under the provision about,
Public
severe-
accommodation,
okay,
right, removing that severe or pervasive
okay,
standard for public accommodation.
okay.
That, I think there's, as we recruit, as we become a more accepting society, recruit more diverse people to the state, which is just incredibly important. I think part of our work also has to be, and something that we are working on, is making sure that employers are doing their work in doing the training, having the internal grievance processes. And we don't want to get employers into a place of saying, we're afraid of getting sued for having a diverse workforce where there might be tensions, because these things really need to get worked out. And so while we don't want anyone to be facing those severe or pervasive issues and have that, and they need the ability to take those issues to court. If we lower that standard, are we going to be changing our ability to create those internal processes and bring about important change?
Senator Brooks.
So, Megan, I hear you, and your testimony yesterday, you raised some of the gray areas that are challenging. I guess I'd ask I think for me, as I've listened to this testimony, to maintain severe or pervasive is become a bar that's been harder to prove, and has been a standard that's too high for some of the harassment that has occurred, and that's been, it may have happened once or twice, but it's been egregious and doesn't meet severe and or pervasive, or has severe but is maybe not enough to hit that bar. What would you propose as an in-between? I mean, to me, I understand the severe or pervasive is a really high bar and has been a challenge for many people, and there's behavior that's just egregious that doesn't necessarily meet that standard. What would you suggest as an in-between that would capture frequent and trauma inducing, but isn't necessarily severe or pervasive?
Right, that place between trivial and severe or pervasive.
I'm not sure anything here is trivial. I don't think.
Well, I think it is. I think that language is that another person in that class wouldn't find to be a trivial.
Oh, I see.
So that seems to be the bar. It's not trivial.
Right.
And
non-trivial versus severe and pervasive.
So I'm not a lawyer, so I hesitate to recommend language that will be interpreted legally.
Well, we're at the point where when you raise an issue at this 2 days ago.
Well, there are
so I think we are at a point where it's great to raise these concerns, unless you want to hold that thought and save it for the House. We are at a point where we need either specific recommendations for something that's not trivial.
I appreciate that. We haven't had like there hasn't been a lot of time
No,
to
that's
talk
true.
or think about this, so it's not like, we've been sitting on this for 10 weeks and are dropping a
Well,
bomb.
I will say, the bill's been out and there was a lot of concern about the good cause termination piece, and that is out of the bill because we didn't have time to pick it up, but, we didn't hear early on that these pieces were as big of a concern as the pieces that we took it out.
Okay,
So it did feel like it fit into this timeframe to take this up.
okay, but the bill came in. The last few days are the first time I've had to focus on it. Vermont has been a pretty much lily white state. There's lots of people that have never seen a person of color, never mind other, And so what do we want to accomplish? We're talking about lawsuits. Lawsuits, in my experience, are the end. They're the worst thing. Everybody essentially loses. We heard
Yeah.
Rich Cassidy. It is a painful, it is an expensive, and that expense is in some way going to filter down. And you might find that it increases the resentment for the people that.
Yep.
Okay, and not all diverse people are absolutely nice. Some may be inclined to bring lawsuits. To me, what you want to set up is a system that develops understanding, that I find myself very hesitant to say a lot of things because it's on the TV, and I've already been told I'm inherently biased against people with mental illness, even though that person knows nothing about me or my, all I said is we need to put guardrails so nothing bad happens. I am inherently biased. That's happened to several people here.
Yeah.
What I think you want is to increase the dialogue and the understanding. And if the first thing that happens is you go to court, because he looked at me funny, which was what my kids started every morning with, and that led to a screaming match. And that to me would be, you would want to encourage employers to have a system to develop that kind of workplace, rather than once you go to court, you're into adversarial positions. And that's going to filter down to the employees. So I haven't heard yet that we have a severe and pervasive problem in Vermont. I'm still trying to understand the problem here so I can work out what's the best step for us now. If what we really want is to build a workplace, a society in which people see each other as people and not as a person that's this color, that color. Blue-eyed blondes are the smallest minority in the world. So I'm a minority, not in
Well, I'm
Vermont.
concerned that this is something that may encourage litigation far beyond where we are now and perhaps where we need to go. The severe and pervasive may be too restrictive, but this, which is wide open, the single incident, and the notion that what a reasonable person is who has the same characteristics would not be offended by is a standard I find difficult. Does that mean that every employer has to bring in 10 people who look exactly like the person who complained to say that they weren't offended? This just seems like a factory for lawyers.
I think it's good to get Julio in the chair speaking lawyers. It is 8:30, so we do, sorry if I cut you off anyway, but
Is there anything else? Did you finish? I just didn't know if you.
That's probably not.
Julio,
But if you come up with something in between, we're ready to hear it.
but I think Julio will start to address a lot of the standards that existing case law already.
And you sent this too.
Yeah.
Yeah, I'm
This-
hoping that'll.
This is, I think
make
it's very
short work of
clarifying.
my-
Yeah.
So
I
help us
tend
walk,
to,
yeah, walk us.
Do you have this in?
It's in your pile.
It's in my pile, so then I
I
have
think.
it. Yes, there it is.
And one could argue these are not states that all have a severe or pervasive.
Yeah,
Well, they all have a severe or pervasive standard of some sort.
I'd like to try to connect the dots to talk about
Perfect.
where
Thank
severe and
you.
pervasive comes from and
And
what
walk us.
what Vermont law actually today says.
Right.
The law that the legislature passed on harassment, and then talk about where severe and pervasive came from.
Mhm.
So existing law in the Fair Employment Practices Act has a definition of harassment. It's been the definition for decades. And it says that the conduct has the purpose or effect of substantially interfering with the individual's work performance. So bad you can't do your work substantially, or it creates an intimidating, hostile, or offensive work environment. So even if you manage to make it through your day, you come into a place and you feel intimidated in the environment, or you feel that the workplace is hostile to you or offensive, then you may have met the requirement for, or the standard for harassment. S-103 keeps that language. It's the same language that's used in the bill. It's on that. The definition is that at the top of page 6 of the bill.
The new draft.
Yes, it includes, it identifies all the protected category, but at the end, on lines 4, it says it interferes with the employee's work or creates a work environment that's intimidating, hostile, or offensive.
Sorry,
Wait,
We
page
might
6?
have a new,
we have a draft.
What we have?
I don't have that.
okay.
What section, or can you
Well, yeah,
find
sure,
it and then?
No,
It should be relatively in the same place.
It's page 5,
yeah, page
lines
5.
15 through 17.
So there is, yeah, it's page 5, and it's on lines 15 through 7.
Thank you.
The one difference that I see in the bill is that the word substantial is removed, so it interferes with the individual's work performance. So where does severe and pervasive come from, actually? So the Vermont legislature has never actually written any laws or passed any laws that states that harassment has to be severe or pervasive. We never have. The language actually comes from a 1986 US Supreme Court case, not interpreting Vermont law, but interpreting a federal law, Title VII of the Civil Rights Act. The Vermont Supreme Court, in a few decisions, has ruled that that federal standard is useful, but not necessarily binding on Vermont, because the language of the Vermont law is pretty similar to Title VII. And so when judges don't have statutory guidance from the legislature, they try to look at analogous laws. And so Vermont, like most states, has laws that look a lot like Title VII, and the courts then look to the federal courts for that guidance.
So can I just
Yes.
clarify, Madam Chair? So severe or pervasive has been a federal standard and never actually one embedded in Vermont law.
Vermont courts have
Have
imported it.
upheld that.
Yeah, it's
Yeah.
basically, this is Vermont common law.
Yeah.
Or it's judge-made law. Interestingly enough, at least for the lawyers, severe or pervasive isn't in Title VII either. And Title VII was passed in 1964. It wasn't until 1986 that the Supreme Court recognized that you could even have discrimination in the form of a hostile work environment. Prior to that, it was just more like quid pro quo. You sleep with me and you get promoted. So it took the U.S. Supreme Court 22 years to recognize that people could be denied equal opportunity because their environment was so poisonous. So what's happened? I'm just trying to put all of this in context.
Yeah.
So what's happened over time is that as courts increasingly apply the severe pervasive standard, it's become more and more difficult to prove a case. But fundamentally, from the beginning cases, the standard really has to do with whether people, going back to the original statute, whether the people are enjoying the same sort of privileges and benefits of employment that people who don't look like them enjoy. That's really where the cases come from. And so dropping severe and pervasive, in a sense, isn't new. It really goes back to the original cases. In one of the cases, it's a 1993 case, Harris versus Forklift Systems, which was a case that held you don't have to have a psychological injury in order to have a hostile work environment claim. That's in the chart. So that's been the law at the federal level for 30 years. Justice Ginsburg at the time wrote a concurrence that said, the critical issue is whether members of one sex are exposed to disadvantageous terms or conditions to which members of the other sex are not exposed. That's how Justice Ginsburg thought you ought to approach harassment cases. And the way she reasoned is that there are other terms of conditions of employment where you don't have to show it's severe or pervasive if you just show it's distinctly different. For example, if an employer decides that they're going to give the most modern and efficient models of computers to the male employees, or they give the laptop computers to the male employees, but they still give functioning computers to women, so women can do their job. But there's a clear preference for one or the other. And we know it's based on sex. The employer might say something like, well, we know men work a lot more at home than women do, so we want to facilitate that and have people more dedicated. That's not severe. Doesn't affect every aspect of your employment. You don't walk in and it's in your face, but it's clearly a violation of law. It's clearly subjecting people to having benefits of employment. So what's happened is that a number of places in the country, starting with New York City in 2007, recognized that, hostile work environment was treating a benefit of employment, which is to be able just to walk through the hall and do your job, was being held to a higher standard than, say, how you dole out laptops. And so they said, we will look at whether, and that was in a sex discrimination or sex harassment case, whether can we really say that women who sometimes receive unwelcome sexual advances are enjoying their workplace in the same way as women who never do? Are you saying, even if it's not severe or pervasive, can you say that they're enjoying the same stature in the workplace? And they concluded in that particular case, no, they weren't. That's been the law in New York City since 2009. So for 14 years, New York City has not had a severe or pervasive standard. In 2018, California, we heard a little bit about California. California also enacted its law and expressly repudiated some court decisions that applied the severe and pervasive standard and said, we will look to whether it just basically people of one category are experiencing inferior conditions of employment compared to other people. So you don't have to look, it's not a question whether it's a breaking point, but are you more or less, but is it clear showing that you have a second class experience compared to people who don't look like you, in the same way that someone who doesn't get a laptop, or in other cases we've seen in the country, police officers, female officers, they get functioning cars, but they get the beaters, and the brand new cars go to the male officers. That's not severe, it's not pervasive, because officers aren't in their cars all the time, but it's clearly a violation of the law. And so California has said, let's reorient a way we look at sexual harassment, so like how we look at other terms and conditions of employment. So that's been the law in California since 2019. New York State also in 2019 similarly abandoned the severe or pervasive standard and went back to looking at it in terms of how do you enjoy your terms and conditions of employment. The occasional insult or the offensive statement typically is not viewed that much, because people experience offensive statements all the time, and they may not be gendered or racist or xenophobic. And this bill actually says that the trivial statement, so a person hears an off-color joke once in their career, can't really show how that makes you an inferior member of your workforce. So, and that's consistent with a lot of the case law that's developed. And then so anyways, New York State changed it in 2019. In 2022, the District of Columbia also abandoned severe or pervasive and said, let's look in terms of unequal employment opportunity, and make it a lot closer to things like who gets the best shifts, who gets the best office. Terribly, I mean, there are cases where certain employees are only allowed to go up the back stairs. This 21st century still exists out there. And so that's what DC has done, and the state of Maryland has also done the same.
Sorry, and then, would you summarize that one again? That's here. Where is that one, Julio? Is that on this chart, the DC one?
Well, I provided,
Yeah,
I didn't
okay.
provide any of the ordinances. I have uploaded those for the committee, so they are
Thanks.
available. The DC one is really quite detailed, and a lot of them really draw some of the factors that you'd look at in terms of the common law. So this chart here, I'll just briefly, in a couple of sentences, what I'll point out is that on the left-hand column are basic standards or rules about how you would prove or what you don't need to prove in order to establish a harassment case. And what I'm showing is that that's not brand new stuff. It really derives from a lot of the judge-made law for the last generation, basically. But what this bill proposes to do, and I wasn't involved in the drafting or the introduction of the bill, but I think what it's doing is kind of memorializing that this part about this vast body of federal law, this is what Vermont wants for Vermont. And actually, it's similar to what the legislature did in 2013 with equal pay. In terms of some of the standards were based on the Federal Equal Pay Act. And Vermont took principles that were derived from cases interpreting the federal law and put them in Vermont law, say, we want this to be the standard because we don't want our Vermont standard to change tomorrow. If a case in New York is decided by the Court of Appeals, and then a Vermont judge is going to apply that New York case. It's kind of Vermontizing the standard in a way. So we didn't think that those on that sheet were particularly controversial. It's things that we, in our day-to-day work, we apply anyway. But there's no guarantee a Vermont judge would do that because Vermont legislature hasn't spoken on the subject. So this, in a way, when you memorialize some of the common law in statute, it's more democratic because you're all elected and accountable to Vermonters. And two, it's more reliable because tomorrow a court could announce a different standard, and as soon as that decision is issued, that's the new law. There's no delayed effective date. There's no stakeholder input. That's just the law as of 1 minute or less than a minute after the decision issues.
So Scott has very kindly
Sure.
shown me that the DC law is also posted on our webpage, which is helpful, although it is right.
So none of the laws, as we've looked at them, and now I've looked at a few cases applying these laws, none of these cases are cases that would allow someone who's offended by a single joke to bring a lawsuit.
Right.
On the issue of single act, that's not really controversial because I think someone else has testified. What about a sexual assault? A sex crime? Yeah, I mean, we've had cases in our office where male workers have exposed themselves to people. That's, in our view, as we've applied the law for a long time in the Attorney General's office, if someone commits a sex crime, that's enough because people shouldn't be victims of crimes in order to do their job, to have their job. So that's not, and all the statute says is that it doesn't have, it could be one. Doesn't mean that they all will be one. It just means it's not a barrier. But there, under the federal common law, there are court cases out there that say, well, in offhand, this only happened, it was only 1 minute in a person's life. And because Vermont hasn't taken a position on this, there's no guarantee that a trial court out there might not find that persuasive or, and a lot of people don't appeal their cases to the Supreme Court. They give up or they settle the case. And so, so some of what I think, our view of this about those different factors is that you're just kind of making a statement about what we think is, our appropriate laws. And I think all of those areas, I think, are appropriate, where you would look cumulatively, you would look at the workplace environment. There are some jobs that, this is the last point I'll make on this subject, but there are some jobs where workers are highly interdependent, right? So if I work with you and if we don't work together, I might be unsafe. I might work in construction. I might work as a firefighter, and I need to know that you have my back. And so if there are statements showing a hostility to me because of who I am or who I worship, etc., even though in another workplace, like say an office setting, might not be as offensive, if the message conveyed to me is I'm second class, and I also know that if you don't have my back, I could be dead because you're not supporting me, that might create a more intimidating work environment. We see it, I mean, historically, you see it with police officers, you see it with firefighters, people who work on oil rigs and the like, where that worker cohesion, and if there's a message sent, people make racist statements all the time, and you're a person of color, that I'm not sure if I'm rolling in the dirt with an arrestee, that those folks have my back. And so you do have to be sensitive to the context. And so that's in the bill. It's not surprising to us, but it's really Vermont speaking instead of us importing cases from outside of Vermont. I'll stop there and answer the question.
Just one of my overall questions regarding this bill is, do you believe that it would increase litigation, particularly litigation that might be questionable in terms of the result? Do you have any concern, for example, that we may be not encouraging, but well, in a way, encouraging litigation based on allegations that are kind of questionable to be able to prove as to whether or not it really constitutes discrimination or harassment, or rather individual acts by individual employees over which the employer could not reasonably prevent from happening in any way, shape, or form, because the employer had either no knowledge of, there was not a practice that was ongoing, there was nothing that they could see that would allow this to happen, but then become liable as a result.
You just raised such a great point, and it's a point that I don't think has been brought out in the testimony. So under existing law, and would still be existing law here, if there's harassment by a coworker and the employer doesn't know about it and is not in a position to do anything about it, the employer cannot be held liable. You have to be able to show, it's longstanding federal and state law. When you're talking about harassment by a coworker, you have to show that either the employer knew it because they witnessed it, or they condoned it or participated in it, or the employee complained about it and the employer failed to take what's the phrase is prompt remedial action designed to stop the harassment. So we turn away cases all the time where when someone comes in, they ask us, do I have a harassment case or not? And they say, well, what happened? Well, a coworker told me. Well, did you report that? No. Were there any other witnesses? No. We'll say, the employer is not responsible for that. And so, the remedy that you have available to you is you tell the employer and give the employer an opportunity to cure that. And hopefully it'll end, and then that'll be the end of it. But if you go there, tell the employer, and the employer doesn't do anything and it starts happening, come back to us and we'll talk, because that's when liability attaches. It's a little bit different for supervisors who are speaking on behalf of the company, who have the ability to hire or fire. For them, for a supervisor, the company would be responsible in the same way if a supervisor signed a contract and under their authority, you'd be bound, the company would be bound based on the authority it gave to the supervisor. In terms of litigation, that's an empirical question. I haven't seen anything to indicate that since 2009, for example, New York City has had an avalanche of these cases. It's hard to know for sure because many employers have arbitration agreements, and so they don't reach courts. But I do communicate with the folks in the New York City Commission on Human Rights, which they're the government people that do the New York City counterpart of the work that we do. And it's not a dominant part of their business. They have retaliation, frankly, tends to be a lot higher traffic, both for us and them.
Well, I'm just looking at, for example, the examples that you have here, and how an employer reading those examples would have perhaps somewhat different conclusions about this. If I take the second example, a single incident may be enough to show unlawful harassment, and then the example is a single incident of sexual assault, very much like you mentioned, which a rogue employee does something, and there's nothing here to indicate that, at least to have me indicate as I read this, that as an employer, I'm not potentially in trouble by having a harassment.
I think the cited case there involved a supervisor. So that's a case where the supervisor is, I mean, and that creates, you know, the courts say that creates an incentive for employers to choose their supervisors carefully because they
Yeah.
are speaking for company and they operate the levers of employment,
Right.
your hours, your compensation, whether you work or not. A sexual assault by a coworker, we've gotten those cases
Mhm.
where the employer doesn't know anything about there's no responsibility for the employer. Vermont law actually has responsibility for the individual. That's one difference between Vermont and federal law. The Vermont Supreme Court has interpreted the Vermont law to permit liability against the perpetrator in such a case, but not, and still, there's very few cases in that sense that are brought because most individuals are judgment. They don't have the access or the ability to bring people
Is there
back.
any guidance that the state, and then whether it be the Attorney General's office, the Civil Rights Commission, the labor, anybody, to provide guidance to employers? And I'm thinking here particularly of a small and mid-sized employer who doesn't have a legal department that can provide the kinds of interpretations that you're giving, to give guidance to employers as to what all of this means to them and their environments and the do's and don'ts, et cetera.
Yes, and I think most folks find one of the more useful resources are a number of guidances that are put out by the Equal Employment Opportunity Commission, where they give case examples of like, this is an example where it would be a violation of the terms and conditions of employment. Here's an example where it would not. They do those enforcement guidances for equal pay. They do it for the Americans with Disabilities Act. They have two separate guidances on sexual harassment, one dealing with supervisors and one dealing with coworkers. So those do exist. I think it is, you know, my other observation for employers that do have HR, and I know that's not most of them, but most employers set policies that are far more restrictive than the law. They'll just speak, and especially when you're dealing with at-will employees, even if it's not severe and pervasive, it doesn't interfere with your work. An employer could just have a policy that says, we don't treat, you know, it's a lack of professionalism. So you're going to be reprimanded because whether you intended that to be sexist or not, it's unprofessional. And so, so we find that usually by the time you get to someone having a legal violation, they're blown well past what employers typically tolerate. You know, so a lot of employers say they have zero tolerance policies. I'm not sure that's really true, but they are far, in our experience, they're far less tolerant of the conduct, at least in their policies. Whether they practice it, of course, is the rub. That's when we investigate cases.
Exactly.
But the policies themselves are usually far more restrictive than the standard.
Senator.
What about Megan's concern that this is 103, so 102, we are extending free speech rights. So I can come in wearing a t-shirt with something that my coworkers find offensive. But I have the free speech. Are we setting that, are we putting that employer between a rock and a hard place?
I don't think so. And this is really complicated stuff. And S102 is a massive bill. I think I wanted to say about 102 that don't deal with this free speech, but I'll just say this. So the employee with a t-shirt has, you know, certain free speech rights. The U.S. Supreme Court is interpreted to what extent that First Amendment right carries over to the workplace. The decisions they've done have typically dealt with public employees because you get fired, the government is acting, right? And Congress will make the law, right? And what the Supreme Court has said in those cases is that employees have a lot of free speech rights, but not if they interfere with the employer's ability to carry out their business. So and the speech, you have a free speech right to talk about something of public interest to the extent it doesn't interfere with the workplace. So a public employee under existing law who wears, let's say, a Confederate flag t-shirt, and that creates turmoil in the office, First Amendment case, an employer could easily say, you know, that you could do that. You don't have to wear that. And employers, I mean, that's been First Amendment law for a long time. Going in the 80s, there's a case out of Los Angeles County involving a district attorney's office that there were comments. It wasn't t-shirts. It was just speech that was really, you know, disgruntled employees talking about their dissatisfaction with the district attorney. And so they sent that person to a faraway office. They sued and they said, you know what? your office grumbling isn't really an issue of public interest. That's just workplace. So you don't have a free speech right to do that. The employer retains the right to control its workplace. So I don't necessarily think there's a tension there. I think there are a lot of whole other issues with 102.
And you're coming back with some language tomorrow, is that right?
No, it's
Now with
there
respect to
already.
102.
Oh, it's there today.
With, I mean, 103.
103.
Okay.
I can't keep.
Yeah, I mean, 102 is a massive subject and,
Okay.
and I don't, there's not enough time to talk about that.
Are you saying massive is the political and religious, or like?
No, the whole
also
bit, like the whole
Okay.
at will thing.
Oh, that's gone right
Oh,
now.
oh, it
The
is.
good
Okay,
clause
yeah.
is gone,
Okay.
Yeah.
but there's still,
It's just the speech issue is left.
Well,
well,
no,
there's not
we-
justice speaking.
Yeah, we had some issues yesterday about we may be running up against the federal fair labor standard by,
And Damien has some.
Yeah.
updates.
Okay, but
Yeah,
it's good
yeah.
cause termination is not in the
Okay,
bill.
okay, yeah, so I'm a
That
little
was
bit,
a
I'm a
big
little bit
chunk. Yeah.
behind.
That
because
that
wasn't
reduces
that-
the massive
Moving
aspects to
Yeah,
102.
it does quite a bit. So, but turning, so I don't see necessarily a tension there. It's a little bit circular when you say your First Amendment right, but the Supreme Court has said what your First Amendment rights are. And your right to wear a T-shirt on the street is not the same right that you have to wear it in a school. That's another
Or
area, or work, because people have people have a right to have a free and fair education. And so there's
Just to just to answer some of the concerns that were raised yesterday.
Sure.
The employer, as far as I understand what you're saying, Julio, is the employer still, even with the changes we're proposing in 102 at the moment, retains the right to control the workplace.
Yeah, I think that's right. I mean, I think I'm a little bit behind in terms of the language there, but yeah, I mean, First Amendment law has never allowed employees to use their speech to upset the employer's operations. And we see that all the time
For a
for,
customer.
yeah, we see that all the time, for example, where regrettably, but we do see it all the time where employees might be saying something on social media, public employees, that undermines the public's confidence in them. Right, so I worked somewhat in the area of policing and accountability, and there are cases I've seen in other states where some lieutenant in an area, maybe he's works on a special investigations unit and he's tweeting all kinds of offensive things there. The employer says, you know what, people are not going to trust you.
Yeah.
So we're not going to have you work in that unit because you've been saying this stuff about them. And that employee doesn't have a plausible First Amendment right. And so, and such challenges have failed typically. So they're having limitations there. And that's why students, if you're in the middle of math class, you can't just start, hitting the symbols and chanting political slogans. There's no free speech right to do that in the schools because schools have the authority to carry out their business. So there are limits in existing law.
Okay, when we get to 102, I think some of us will have more questions on that because, anyway.
Senator.
Is in 103, is there a differential impact or are there existing conditions that make public employers different than private employers?
In 103, no.
Yeah, okay.
No, for the sexual harassment or equal pay. There, in terms of application, the only difference I would say that arises when we see differences between public employees and the private sector, and this may affect how you decide policy, is that, remember, public employees' compensation is public. So you can find out how much I make and I can find out how much my coworker makes.
And how little we make.
And how astonishingly little
And how astonishingly little. I like that.
our legislators make. But in the private sector, that's generally not true. So there's a lot less wage transparency. And so that's where equal pay law originally was designed to do its work, was to remedy pay disparities that arise. In our experience, sometimes employers aren't even aware that they have those disparities. They've kind of grown into the system. I think someone called it systemic before, and that's often true. We often don't see any kind of malice or bigotry there. It just kind of sticks to the employer like a barnacle or something, and equal pay laws there to strip it off.
Okay, thank you.
I see you with your camera on. I really wanted you to be here for this discussion. We're already a witness behind, and I wonder if we can have you back at 11, possibly, to respond. Thank you so much.
Yep,
Madam
11 is
Executive.
fine. Thanks.
Okay, thanks so much. So good. Yes. Do you have another question?
Yeah, I guess what I'm hearing you say to us, Julio, is that many of the changes that we have an opportunity that we've actually never adopted and set in statute are values, in any way, that we have relied on common law and on
Yeah.
and the federal law and what we like to say activist judges banking law, that we've relied on that, and that this is an opportunity for us to stay in statute Vermont's value in terms of how it views these issues. And I think the most compelling thing for me and the reason for us to do this, I mean, I so fully support this work. And want everyone obviously to have a safe, productive work environment where we want no distinctly different treatment for any class of person. But the main difference in terms of, I mean, there can be such an egregious single act that is traumatizing. And I think it, obviously rape is an extreme example, but there are some really brutal single acts that can affect work performance, can affect work environment, can affect so many aspects of how you work productively. I think that's why at the moment I am still feeling, I still feel very strongly that we need to move this bill forward and set in statute Vermont's value for a workplace and for how we value each other in a productive work environment. So I hear what that's what I hear you saying, that we have the opportunity to do with 103. Is that?
Yeah, I guess what I would say,
or my
related to that,
much of a Pollyanna?
No. And regrettably, I can give you examples of single act harassment that doesn't involve physical conduct.
So we need that. I think we need, I mean, Anne has asked, Randy's asked, what's the problem we're solving here? And what in Vermont have we seen as
often those cases are cases involving the chief executive of the company making demeaning or maybe unwanted sexual advances on an employee. And again, regrettably, the cases where courts have recognized it often involves a group of public humiliation in other employees. So there would be cases, it's the Christmas dinner. President of the company and sole shareholder gets up there and then proceeds to make a bunch of very offensive statements about maybe a female, maybe an executive assistant that he works with in front of everyone. And then maybe there's just one other comment that he made when he hired her about, if you ever get a divorce, you've got my number. And so courts will say in that sort of cases, you're humiliated in front of the workforce by the person who employs the HR department. Like, you have nowhere to go. And so a person will feel like that basically, puts me in that situation. But other cases, the CEO says to somebody, hey, you look really great in that suit. It's not that significant. Where the language in the existing statute that you put in before, from the CRU's perspective, where it says it's got to be intimidating, hostile, or offensive work environment, not a bad day, but a work environment. For us, we don't view that in our application of the law as playing tennis with the net down. There is a bar there, and we turn away cases all the time where people will say, people will ask us. It's not like they're filing; they just call us and ask. That's what we're there for. And we'll say, is this? We'd say, your best course is just let people know, or somebody you trust at work go with you, talk about it, and try to remedy it inside. So we don't feel like there is no standard here. I mean, you're keeping the standard. That's the language we apply on a day-to-day basis, because that's the language you wrote, and we took an oath to apply the laws you passed. And we look at what the court says as well. But I didn't have to answer your question earlier. Do I feel like like the language that would be left would be just like a free-for-all. I don't think so. Because there are lots of cases out there that we can still look to talking about intimidation, hostility, or offensive environments. Whether that's enough for people, I think people can have different points of view about that. Before I jump off the seat here, just a couple of points to follow up what I heard today. Relating to this issue about whether most people seek reinstatement. Rich Cassidy said he's almost never seen it in his career. It might be because I don't know for sure, but it might be because he's an attorney in private practice. We do see people who want reinstatement. If you're settling a case and the remedy is to return that person to work and then earn their future income as opposed to take a cash settlement, there's less of an incentive for folks in the private sector. I used to work in the private sector and do employment law. There's lower value of the case because as an attorney, I don't get a piece of your future earnings. I would get a piece of your settlement. So it could be that by kind of the way the market works, that the people who want reinstatement go to the public agency. The first thing we do in every case is this a relationship that we can repair? Because usually the cases where something bad has happened, that employer trained that person, made the investment, the employee made the investment in the company, may have developed skills. And if there is any chance to repair the relationship, then we'll try to do it. So we do, it's not, I wouldn't say that every day, but it's certainly not unheard of. And reinstatement is not unheard of, not only in our office, but when we talk to our peers across the country who do the same thing in the 50 states in DC.
That's a really good point. Senator Brock.
Just to follow up to the discussion we had a little bit earlier about additional litigation as a result of changes that we made here. Are there any cases or calls that you've gotten from people who are concerned and you've had to turn them away because you didn't believe that our current law went far enough to deal with their problem from your perspective? Is there any way that you see that changing? Are there cases, for example, where people have made inquiries about problems in Vermont to you that you've not been able to deal with, but that you would be able to deal with the changes being proposed here? In other words, will this make a difference?
Yeah, I think so.
Can you give us one or two quick examples so that we can understand the context?
So I'll use a hypothetical. We have so many cases and so many bad things happen. I want to just use something that doesn't necessarily bring up a case because who knows who's listening. It might be the victims of the cases. But I mean, a classic example that happens in a workplace would be the annual Christmas party, where that's, all bets are off. And for a lot of, and often regrettably, but often the targets for the annual Christmas party are women. I mean, we've been talking about sex harassment a lot, but there's racial harassment, but that's the annual Christmas party. So once a year, the Christmas party, this happens. And, there are reports that'll say that, well, it was all verbal. So it wasn't groping. Groping, usually you will get to severe. It wasn't pervasive. It was once a year. So you've been working 5 times, but in terms from the employees, when they try to bring that case, they're saying, you don't understand it. If I work with these same people every day and they see what I'm subjected to. And often those cases can be coupled with other inferior terms of employment. In the Harris versus Forklift case, for example, that was a case where a supervisor, they never decided whether it was severe and pervasive. They kicked it back to district court. But that was a case where a supervisor would, a few times a year, refer to the complaining employee in that case as a dumbass woman in front of customers. Told that woman and another woman every once in a while who were looking for change, this is back in the days where we had payphones, that, yeah, he had some coins in his front pocket. So, and typically doing it in front of other people. And so it depends on what court you go to as whether they would consider that to be severe or pervasive. It can be, it's not just like one comment I experienced and then I went a year and nothing happened. And then somebody else did something. Usually, it's usually a small amount. And the question is, how much is enough? And no court and no legislature is going to figure out a
How
magic
much is
number,
enough?
because every workplace is different. Like I said, like if I'm on an oil rig where my spouse is 100 miles off, away, and I'm depending on these people for my safety, that's different than if I'm working, at an ad agency or something like that. But there is no question, and that we and the EEOC and everybody else who does the government work, that we turn away cases because we have to tell them, yeah, this is probably not going to meet severe or pervasive. Sometimes what we'll then try to do is just see if we can mediate the dispute with the employer, find out what the employer, because we don't know if the employer knows. All we have is the employee's version. But we want to try to see if we can mediate that case, see if the employer really knows, because we don't run off the court. And the last point I want to just raise on the issue of hardness and like whether people are so eager to sue. So this just refers to work that our office does, and it kind of puts us in the context of this. Last July, we settled a sex harassment case. That was for our office, the largest sex harassment case in our Attorney General's office history. It was a settlement with a McDonald's franchisee, the largest one in Vermont, has some stores, restaurants in outside of Vermont as well. It's $1.6 million. Case came to our attention when one employee, a woman in her 50s, complained to the EEOC, which did an investigation and brought suit. Turns out that employer was someone we had previously a consent decree. My predecessor had a consent decree with the same employer back in 2007. So we intervened in the case because we had a repeat offender. We had terrific work in our office done by Emily Adams, my colleague, and our investigator, Abby Lieber, to work with the federal employees. $1.6 million settlement for a class of victims, many of whom were teenagers, male and female, or were harassed by a single manager who was permitted to do it. The last count in terms of, I think we have identified, originally the case was one employee who did come forward. We've identified 47 other victims, for whom we and our federal partners have vetted their stories and determined that they're entitled to some part of the settlement fund. So for us, that was a lesson for us about how willing people are to go to court. That one person didn't go to court. She went to the EEOC, which is confidential. Equal Employment Opportunity Commission, which applies to Title VII. So it was a real lesson for us in terms of how these, and the conduct went on for years. I mean, years. When I think, we took depositions. I think our youngest witness testified was 16 about events that had happened a year plus earlier. So our experience and our recent experience, reminds us that it's not easy for people to go forward, and hopefully we're hoping that was like the outlier case. But while we were,
So I just have to follow up because I think it's one of the questions that keeps bubbling up, which is when you talk about how many cases you turn away because it doesn't meet the bar of severe or pervasive. How many cases a year do you think are turned away in Vermont because it doesn't reach that bar? Because that's really part of what we're trying to get at here.
We don't keep numbers like that because we're I think as Rich said, we're overworked, and every minute that we're compiling stats, we're not investigating cases. So I don't know.
Right, I understand,
but it's not rare.
Insignificant.
It's not rare, I would say, and it's not necessarily sexual harassment. It's harassment of people with disabilities, racial harassment, and so. I mean, it can be hard, and yes, but we see the full range, and we also see people who, are asking, or maybe they've gone to a lawyer who's already told them this isn't a violation, and so they come to the Civil Rights Unit thinking they'll get a more generous reading, and they'll tell us, yeah, someone made this, told this dirty joke at the picnic, and we're like, is there anything else? How else is working? Yeah, it's fine, but that was really offensive. It's like, That's not going to meet, even without severe pervasive, that's not going to meet the standard. It's unfortunate, and we'll try to give them ideas about how to deal with it and work. We want people to try to deal with it in-house whenever possible. It's just better for everybody if they can resolve it that way. But yeah, I don't have a number, but and I think if you put on Zoom 50 other people who have my jobs in the other states, we'd probably all say the same thing. I mean, the question is, it's that balance between, well, if you change the standard now, do you bring in you bring in more chaff than wheat? That's a legitimate question to ask, and I think different people can have different views about it.
It doesn't sound like it happened in New York, or what you implied in 2009, New York did not see it. But
Yeah, and I was at a conference in the fall with New York State, where the people that do our work, but they do it for New York State. And in terms of the number of cases that have come to them, I don't think it's changed. I think it's changed how they view cases. They find more cases meet the standard. But in terms of new cases, and just to be clear, I mean, do some people make up allegations or exaggerate allegations? Yes, they do. That's true for everything. That's, we have Medicaid. We have a Medicaid fraud unit in our office. So those are usually professionals, licensed professionals who are overstating what they do for patients in order to get more money. We still have Medicaid, but we just have to guard that. In our experience, when we have cases where we think things are fabricated, they don't fabricate just short of severe and pervasive. They make it well past the line. Because the worse it is, the greater the damage. If that's a person, that's what they're doing.
Right.
The greater the damage, if they're that kind of person. So when we encounter exaggerated claims, it's not like they bring it just short of the line. If they're in a room and the door is closed, they don't have a marginal comment that they're going to say the boss has. They have a much stronger one. So as far as we can tell, we don't encounter many just like purely fabricated cases out there. And like I said, the people are going to lie. In our experience, they lie big. And so we don't think severe and pervasive makes a difference for those people. So unfortunately, there are people out there or everywhere that, will try to use the system and manipulate it, but we don't see that very often.
I'm going to take Senator Harrison's question. This is really important to have our IG's office present. We're moving a lot of things back just to anticipate we're not having a break. People can just go do what they need to do when they need to do it. So
thank you. No, this is really helpful, and the chart's really helpful.
We weren't sure, so I'm glad.
No,
the chart's great.
It is, to me anyway.
Okay.
So if this bill does go through and these things that courts have to find out in different ways are all in one place and it's more clear, would that speed the process at all? Would it help the courts make quicker decisions or easier decisions?
I think the short answer is no, because the slowness of the process has more to do with the pandemic and the judicial system and resources. I don't think it's because judges are struggling with what the standards are.
Okay.
I do think that clarity and clarity, however you said it, and that's your job, that's not ours. Clarity, however you said it, makes it a lot easier to train employees, so you know what the law is and you know where the lines are. Because right now, HR professionals, they go to seminars and have education, and they'll say, well, this is the standard, but there's a case in Indiana that recently said this, and they're interpreting the same Title VII. And so how do we know that's not a lawyer in Vermont? We all have Westlaw. We can all find the Indiana case and say, hey, judge, you should it's not binding on you, but it should persuade you. Right. And so clarity, however you said it, I mean, you could say you want severe and pervasive and put it in the statute. Then we know. Right. That's your call. So it makes it a lot easier to train when you train to the standard. Okay. That's true for every law that applies to the workplace, like with disability, or if you have a regulation authority, like the EEOC has the right to put out regulations where they give examples in the regulations of what constitutes a reasonable accommodation for disability and so forth. So there is some benefit to doing that. It gives more. The other thing is that it provides a little bit more stability and predictability for employers. So I know that a new case in the Second Circuit, which covers Vermont, Connecticut, New York, doesn't, if it deviates from the Vermont statute, I didn't know that case isn't really relevant. I mean, that's what you did in 2013 with equal pay, because there were equal pay cases out of different circuits in the country that interpret it very differently than we had in Vermont and the Second Circuit. And so what the legislature did there was say, we like the standards that apply here. Let's put them in our statute. So the appointment of new judges, or bad cases or good cases that come to the court, don't change how we actually do our business, so that we have predictability, which is vital for the operation of businesses. To have a stable, predictable environment, and to know where your target is so that you can reach it. So that we think clarity is good.
Great.
Thank you.
Thank you.
Thanks so much, Julia. This is really helpful. So we are behind, I think, if people.
That's my fault.
No,
No,
it's actually ours.
there's no-
it.
I mean, it's just, one of our challenges is we don't have enough
It's
time.
across several weeks, so
Yeah.
it's just gonna happen. Bill,
Yes.
thanks for your patience.
Oh, no.
Thanks everyone in the room for your patience.
And I'll try to be quick-ish. First, I have to say this is a much more comfortable witness chair than this committee has traditionally had.
Well,
Major
thank you.
improvement.
Yeah, good. I'm glad you're appreciated.
So for the record, William Driscoll with Associated Industries of Vermont. Appreciate the chance to speak to this bill. I am not a lawyer, and so I'm going to be touching, I think, on some concerns or questions that we have based on interaction with lawyers on these issues over the years. But I would stress that I think all the questions or concerns I might bring up, it would be good to have more expert legal testimony to sort of follow up on those issues.
I do want to highlight, sorry, before I
Sure.
forget,
No
that
problem.
somebody suggested we hear from Steve Ellis from Paul Franklin College.
He couldn't make it this morning, we'll send it.
So there's a more written testimony from an additional legal expert.
And a constituent.
There you go. So we are hearing from somebody.
Yes, and actually, and Steve is a great expert on these things, and I did get a chance to look through his written comments, but I think if you had a chance to also talk to him, I think that'd be very, very helpful. in terms of
It wasn't my
questions.
schedule, it's his. but-
No, I understand. So I'd like to just maybe go through some of the issues with 103, and then I have a couple of comments on 102. I think Megan Sullivan, raised a lot of the sort of employer or concerns that there might be. But I'll sort of just touch on a few, and just could go through, and I apologize, I'm working on the earlier draft. I know there's a new draft this morning,
Mhm.
so I don't know if my
Oh, the
page numbers
page
might be a little bit off. One thing, and I don't know if Julio had a chance to address this more. I know the question was raised in the equal pay provision on the second page.
Maybe just use
number
the
7.
section numbers.
Yeah, number 7.
Mhm.
I think the question was raised, if you're bringing in disability into this statute, it raises the question of whether the employer knows about a disability. And I believe the issue earlier this week was probably, does that kind of create a catch-22 or a dilemma for employers? And I think part of whether employers would want to inquire or know more about their employees and potential personal issues they might have. I believe, looking briefly over the new draft line, I'm assuming that some of the new language is attempting to address this, but in the sense of making sure that the privacy of the employee is protected, and so that the employer maybe could not make more inquiries or get into that. But that wouldn't seem to alleviate the initial concern. In other words, the exposure of employers to an equal pay violation based on something that they're not aware of.
Okay,
So-
so, and you're referring to, there's new language on page 3
Right.
that speaks to privacy, but does it kind of.
get to the core of
Absolutely.
those first.
Fair.
So I don't know if I have a suggestion about that, but I would just flag that as maybe something Damien or Julio or others could follow up on. And a similar sort of catch-22 question, and this is really honestly a question, and there may be a clear answer from folks. But going to what's here is page 3. It's little 4.
Sorry, what, where?
So a bona fide factor.
Yes.
So it's
On page-
above the new language on page 3.
Yeah, little Romanet 4.
Yeah. So my question here is, I don't have an immediate real world example off the top of my head, but when it comes to job related reasons why there might be differences in pay, obviously there are scenarios where pay is based on performance or productivity or other goals or other criteria like that. And again, I guess in a situation where there's a physical or mental condition that affects those things and therefore could lead to a difference in pay. My question is like, which wins out? In other words, if on one hand you have a job related reason, but that job related reason is inextricably tied to the disability, which wins out? Is that still a violation or is it not a violation? I don't know if there's any.
I know, I was gonna say, you're not asking any lawyers as far as I
Yes, I
know.
know.
Right next to
Yes.
But we have Julio and Damien. Julio looked like, I didn't see if you.
He's John.
I'll let Julio.
Yeah.
Julio's so eager. He's like right there.
Julio Thompson, Attorney General's Office, Civil Rights Unit Director. I think it would not be discriminatory or a violation, because an employer is entitled to, even under existing law dealing with disability, to hold employees to certain performance standards. So if you have someone, the job requires, you can demonstrate the job requires someone to type 100 words per minute, and someone has a disability and types 40 words per minute, an employer under existing law can say, you don't meet our hiring standard because there's no way for us to get you up to 100 words per minute. So I think in terms of looking at the outcome of the employee's performance, you sold this much this year versus someone else, and and there may be a reason for it. For one person, it might be a non-disabling reason. I was going through a divorce. For another person, it might be because there's a disability. If the person with the disability has the tools to compete and still doesn't meet, another person's performance level, then the employer is operating within safe waters. So that would not, from our enforcement position, we wouldn't consider that to be discrimination on the basis of a mental condition or a physical condition.
Does that answer your question, Bill?
It does, and it does. It's certainly an intent, and whether or not the language is tight enough or perfect enough. I'll just raising the question. I'll certainly would defer to Damien or Julio to think about that.
Okay.
So, all right, thank you. So just moving a little bit further down, we're just getting into the do not rehire issue. I think you've heard the arguments why this can be beneficial to have these kind of settlements for both sides. I know that in looking at this issue last year,
That gets us over.
it's just further, just a couple paragraphs down.
It's the new on
I.
page 4, little
I.
a Romanet 1.
All right.
Oh, it's I. Okay, got it. Yep.
I think when this issue was being discussed in the last biennium, I did try to look around, and I think I only found maybe 2 other states that prohibit this sort of thing. That might be more at this point. So I think there's something to be said that, by and large, the vast majority of jurisdictions do allow these kind of provisions. You've heard the pros and cons from lawyers, I think, who represent both employees and employers. I'll just let those arguments sort of stand. The only other question I have with this provision is the bottom half of the paragraph where it says any provision of an agreement to settle a claim of a violation that basically has one of these do not rehire provisions is void. I don't know if that's retroactive. If that's going to be impacting settlements that have already occurred? Certainly, if it would, that would be a serious concern.
That was a no, period. I mean, is there like more
Yeah.
to say?
Julio Thompson, Attorney General's Office. Now, constitutionally, legislative bodies can't write laws that impair contracts that are already in existence. It's part of the Constitution called the Contracts Clause. So it would only be enforceable as for agreements that are made after this law went into effect.
Yeah, and also under 1 VSA 214 of the Vermont statutes, our laws have prospective effect unless we notwithstand that. We haven't done that in this case. So in order to overcome the contracts clause, you need to make a very high showing in court. And then in order to overcome 1 VSA 214, we have to say it in the statute. Otherwise, that applies and makes everything prospective.
Great,
So,
thank you. Moving on to sort of the heart of the matter in terms of severe or pervasive. I think you've heard the concerns from the employer perspective. Obviously, the question is sort of twofold. Is the current standard really too high or too restrictive? And then is this replacement language too low or sufficient? I think in terms of what I think as Senator Clarkson said, it would be good to get more actual examples, hard examples of where this current standard has been an unduly high burden to overcome. I think it's not clear that I think we have a really strong understanding or examples to look to see that this is actually problematic. I think to the question that there's a concern about a tendency or toward requiring both severe and pervasive. I think that should be a fixable thing. I would think, frankly, I think that's not a hard thing. I think to make clear in statute that it could be either one.
Sometimes we talk about what are examples of where it's falling short, but do you have examples of where, you worry that this will bring new cases that you can point out? I mean, do you have HR departments in your organizations that say, that doesn't present a psychological injury or that didn't affect your work performance?
Mm-hmm. And that's the sort of thing I think.
What are the concerns?
Right. Well, in many ways, that would be trying to kind of prove a negative because that's not the case in terms of the standards that are in place. In other words, it should be proposing changing those standards potentially to a lower one.
But do you
sort
of say that doesn't really, that we're not going to change anything about the workplace because of your complaint? We're not going to address an issue because this doesn't really.
Oh, in other words,
it's
this new standard.
Right. And what I think we heard from Julio is nobody's walking around saying, is this severe or pervasive because this was it's a US Supreme Court case? What are the standards that you all are using to look at harassment in the workplace?
Yes, and that would be a question for employers.
Okay, so then what is the concern?
Right.
So the concern that I express is that if you take away, it doesn't have to be either severe or pervasive. Is that going to lower the bar too much or not provide really any bar? Now, I understand that, for example, it's followed by number 2 there, that a reasonable employee with the same protected characteristic would consider to be petty or slight or trivial. I think as was referenced, actually speaking of Steve Ellis, I think referenced in his written testimony as I was skimming through it, that would seem to be setting up a battle of reasonable employees. Where it's not as objective a standard as might be desirable. But again, I think talking to lawyers as to how that will play out in the courts will be helpful. So that's some uncertainty and some concern, and that just simply gets back to, is the existing standard really a problem? Because I think you need to be careful. I think lawyers are the first ones to say that whenever there's a change in statute, there's a flurry of litigation to figure out what that means. And I think there would be a concern that by explicitly rejecting the sort of most prevalent court or precedent of severe or pervasive, there's a suggestion that it should actually be much less than that standard. And I think that would be a concern there. I think that to see that other states have, or that there have been some jurisdictions that have rejected that formulation. It would certainly be helpful to see what they have put in place and to see if it's the same thing as the replacement standard that's in this bill. But I think there is more to be investigated and heard from about how well that has gone. You know, I understand that Julio was saying that he hasn't heard of problems, but that, you know, that doesn't mean that folks who are either you know, employer or employee lawyers, whether they're aware of examples of where the replacement standard has raised concerns. So I think that's just something that would be important to hear from more lawyers who have been practicing in the field.
I'm sure there are as many lawyers as we could hear for the rest of time.
Yeah.
If you come across a case or a piece of testimony that you can pass on to us in the next
Yes,
couple of days, an article.
Yeah, we'd be
Please
happy
do.
to check on that. And I think kind of getting to that point, I know the concern was raised about moving this legislation in time for crossover. I guess I would just, with all due respect, I would just observe that these are certain very important issues and could have very consequential impacts in terms of creating new precedents, creating new litigation to define where the lines are. It's important to get this right. I don't think there's anything inherent in this bill that there's some urgent requirement that this has to move this session. I think getting it right is more important than getting it fast. So I would just encourage the committee to take the time that it needs to really flesh out these questions rather than being concerned about crossover.
I mean, I'll just say, you know, we hear a lot of urgency from the business community when they need something.
Mhm.
And, you know, we have heard a sense of urgency from people who represent very voiceless employees and people who face, you know, hostile work environments every day. We are actually in a worker shortage, not an employer shortage. So, you know, my sense of urgency errs on the side of how to have strong and safe workplaces for people, and, you know, to set a standard that may be similar to other states and jurisdictions that have, you know, a robust workforce that's diverse and makes people feel dignified.
Yes, and those are all important goals and priorities. It's just, again, if we get this wrong, the consequences could be, you know, pretty severe as well in terms of the legal issues.
So Bill, if you could give us a notion of, if the Associated Contractors and Associated Industries, give us a picture of your members and how this, how many, I mean, is this have there been lots of cases with your members or no cases? I mean, or very few, or ones you know about? I mean, how big, you know, I'm just curious from your industries, the industries you represent, has this been, you know, McDonald's is not one of your industries, and that had the biggest settlement Vermont's had, I think, in recent history, right? I mean, so do your members have a number of cases brought against them? Is that your major concern here, or is this more abstract?
I do not know the number of cases that have involved manufacturers or other businesses specifically, but the question is the other way around, insofar as you're proposing to change the standards, right? And therefore that will change the benchmarks or thresholds for cases.
Yeah.
It may. So that would create a new environment. So in other words, we're creating an uncertainty or an unknown that I think getting legal expertise to advise you is what the likely outcomes might be is helpful. But by the very nature, you're creating a new rule book. There is no track record to refer to. So
I'm curious just to know about the industries that you represent. Just
primarily manufacturing.
But do you have examples?
Like
how many?
Yeah, it's a couple hundred. We also have associations that are members, so it's hard to stay on top of the numbers.
So he represents a lot of.
Yeah, we
Yes.
didn't
That
give
would
you
be-
a number, and maybe we didn't give you an opportunity to really.
Oh, yeah, I'm sorry.
Your work.
Yeah, so it's just broadly manufacturing. In other words, it's not like very granite where there's like one sector. So
Okay.
we've been around for 100 years. I've been around for 21 years. Yeah.
It's hard when you have to say that out
Well,
loud.
Yes. it does.
But I mean, yeah, it would be curious to know of your members. I mean, just to follow up, how many have had cases or, you know,
Well-
just, you represent a lot of industries where this may, you know, where these issues may arise, where there have been cases where they've been settled, where people have been reinstated. I mean, you
Yeah.
represent a range of,
Well, I think by the very nature of these sorts of things, that's probably not something that individual companies will want to talk about one way or the other. I certainly don't think there's anything particularly about manufacturing where there would be more instances of these than the norm in businesses. The only thing I guess I would say is, I think because of the nature of manufacturing and the nature of sort of benefits and payroll that are definitely different in that sector than others, we probably have a more, I don't know how to say, maybe a more robust HR.
yes, I was gonna say, you
function,
have
for
probably
sure.
some of the best HR, you
Yeah.
represent some of the best HR in the state, is my
Yeah.
guess.
But
So you probably have best policies, best practices.
that being said, you know, manufacturers come in all shapes and sizes. So, you know, a 5-person
Yeah.
operation, whether you're a manufacturer or not, you're gonna have, you know, HR challenges. So,
Absolutely. But
yeah,
clarity is helpful. I think that what we haven't necessarily had in our law and I think part of the objective here is to actually set in statute what our law is and not rely on common law elsewhere and federal law. But
Yeah. And I apologize for my promise to be quick is.
Is
No
that-
worries.
Okay. I mean, we do, you know, we are gonna have to end in a minute or
Yeah, I
so.
can drive it very.
Okay, great.
I would just flag on next couple of paragraphs. It's where C is struck in a small 3. It's taking away substantially interfering and just simply interfering at all. You know, again, I think that's, again, whenever you start to take away those qualifiers, it raises questions for what's
Okay.
left. And I think, yeah, I think again, you know, a lot of this new language that's bringing in, including like the definition of harassment and the various qualifiers. I appreciate that from Damien's testimony that all this is based on case law elsewhere, but I think whenever you take case law, you put in a statute, we may get different views from lawyers in terms of, once you put it in black and white, are you getting it the right effect that you think? But that's just really more of what I was recommending before in terms of maybe getting a few more legal voices in. And I think that that's it. The public accommodation provisions, obviously, I think it's just parallel issues, and I would defer to Megan or other organizations that really represent those kind of businesses. I'll just very quickly note on with regard to 102. I'm very, certainly, I think very sympathetic, and I think it's very understandable. I think the goal or the intent of protecting free speech and not having captive audience or other things like that. I think Megan has raised in her previous testimony, maybe some of the unintended consequences or permutations that you might want to think about. The only thing that I would bring up is it's not clear to me on where it defines what political matters are. And that's at the end of section 1.
sorry, now switching to
Yeah, which we're
102.
about to do, so that's
Yeah, so
fine.
page 3, well, yeah, I think it's still page 3. I don't think you have a new draft of this one.
Page 3. Yep, which number?
So line 9, little 1, or not little 1,
Political
where it
matters.
says political matters. So certainly as you read through that sentence, I think all that makes sense as political matters. I would just simply question whether labor organization is a political issue. Now, obviously, that can be a very fraught issue and between management and employees and labor unions. But I think the existence or non-existence of a labor union in a workplace is more of a mechanical or structural issue. It affects how employees and management communicate and things like that, but it doesn't implicitly address policy or substantive issues such as all the other things that preceded that in terms of legislation, political party, things like that. So I just would question the appropriateness of including labor unions in political matters.
So give it its own section.
I think maybe give it its own section then.
That depends on what you want
It's
to
still
do.
gonna be in there,
Well, it
but
depends on what you want, what you're trying to
Give it its own
accomplish
section.
with it. Whether it's appropriate to, I would have to, if you want to create a section about labor unions, I'd be happy to look at it and provide feedback.
but I think
I
you're,
just don't think it's, I don't think it's a political matter.
okay, so if your feedback is about it not being political.
And then once you get into what are you trying to
Mhm.
restrict or prohibit in terms of communications about unionization or not unionization, then I think there's a question about whether that would be appropriate or not,
Sure,
but I just sort of see it.
okay, thanks so much, Bill.
Now I had a question for Julio.
Okay, yeah, Julio, and then we'll, while you're asking Julio a question, thanks for your patience, if you could get in the witness chair, that would be great.
And just for the
We are
record,
switching over to ag.
we do not support carb check.
Okay,
That's like basically having somebody standing with you in the voting booth kind of situation. And I'd be happy to talk more about it if you want to take the time.
it's helpful to know the lack of support.
Yeah, thank you.
Okay, yeah.
My question for Julio is,
But
Would you like me to sit in the chair?
I mean, this is a more comfortable
no.
chair. I can say.
I don't care where you sit.
Yeah, can I just ask them a question about that?
Sure, okay, so Anne, you asked your question to Julio.
Yeah,
and then we'll keep you in the
The do not darken my door.
Yeah.
I can see the state of Vermont and saying this person, you know, you can't work for any division, you know, I had a problem in Bennington and now I can't work in Brattleboro or Burlington. But I think we've heard some of these are hard fought. Is anything, if we say you can't do it, do not darken my door, is that in any way going to open an employer who has a couple of employees who has just been through a very difficult court case, has been accused, the employer feels unfairly of doing some awful things. If that employee comes back and says, okay, I want my job back, and the employer says, no way, is that employer going to be open to a charge of discrimination? I'm not hiring this person back because they're in a protected class. Are we setting that employer up for further?
So for the record, Julio Thompson, Attorney General's Office. In terms of like what the state of Vermont does, you probably want to talk to the Department of Human
Yeah, no, that was
Resources.
just a big, that's a big employer.
Okay.
But most of our employers are very small. The employer, the employee, you know, it's face to face. Are we going to put that employer in a position where he's or she is going to feel pressured to hire back someone they really don't like very well and don't feel would be conducive to a friendly workplace atmosphere? I mean, are we setting that employer up to have to be open to a further discrimination complaint? Because they, okay. I got dueling lawyers.
Right, well, and Damien, I mean, you know, yeah, do you want to answer this now? Okay.
I'll let Julio go.
No, go ahead, Damien.
Okay,
You wrote it.
Yeah, so,
That was a simple little question.
this question came up last year,
Okay, wasn't here.
on the same provision in the bill that was, I can't remember, I think it passed out of the Senate last year.
Yes.
Yes, it did.
So the answer is that what the bill prohibits is having the clause in the settlement. It doesn't prohibit the employer from, if the person reapplies for their old job, it doesn't prohibit the employer from saying, I can't have that person in the workplace because there's a toxic relationship or they're not the most qualified person for the job. The employer has the same considerations on discrimination and hiring as they would under existing law. So under existing law, you have there's a bar to prove that it was a discriminatory hiring decision. That doesn't change under this. The employer is free to say, I'm not gonna hire you for this job. What they're not free to do is include the no rehire clause in the settlement. So, and that it really gets to, you know, if the management turns over at the employer and maybe they decide to bring that person back, that allows that in the future. But there's nothing that says that if that relationship soured between the current supervisor and the employee, the current supervisor is on the hook to bring them back. They just can't prohibit them from ever coming back in the future.
Okay.
So do you have a different answer, Julio?
I don't. I mean, every employment decision, whether to hire or not to hire someone, whether to promote or not promote, in terms of what is an employer at the risk of someone saying you used an unfair factor like sex, age, or the fact that I raised the prior claim, I previously made a workers' comp claim, for example. That it's the same for all employees, so it doesn't really change. It doesn't create a new standard. It just says it's treated like all other hiring decisions. Well, while we're on the subject of equal pay, I just want to clarify something Rich Cassidy said earlier in his helpful testimony in terms of talking about how these cases work from a practitioner standpoint. In 2020, he did mention California changed the law. In 2020, California prohibited these no rehire clauses for all employment disputes. So that could be a dispute about workplace safety, about breach of contract, for every employment dispute where the employee made the claim of some wrongful act before they reached the settlement. So it's in California, it's not just discrimination, it's all of them. So I'm just saying that's what the law is. In terms of, you know, do people turn around and sue or claim that, you know, like you're discriminating against me? I can only speak from the civil rights unit perspective. I don't know, like other parts of our office deal with the state as employer, for example. We don't encounter it really. We haven't, I don't know that I've seen any case. I think I testified about this back in 2018 when you did this for sexual harassment. I've been in the civil rights unit for over 10 years. And we get 1,000 calls a year or more. I only could find one case where someone later applied for a job and then was fired because the boss said they were on a no rehire. They didn't have a settlement agreement, but that person had been placed on the employer's no rehire. And we found that was a violation of the law because and when we got to witnesses, the person admitted it was the fact that the person had previously complained to our office. That was the reason they were on no rehire.
Yeah.
So that was our only case. Now we could be an outlier. I'm not sure because, like I said, not every case comes to us, but we don't we settle cases all the time. We love to do that. We love to get resolutions. I can't think of a case where that same person's come back and applied for a job and said, I've been discriminated against because I settled the case. Other people, other witnesses may have other stories to tell, but that's our experience.
Yeah.
The law now doesn't, if that employer doesn't want you back, the law now lets the employer say, fine, I'm gonna pay off $10,000 and you don't come back. Now, the employer may say, fine, I'm only going to give you $9,000. They can't say, don't come back. But they really don't feel that having that person in their office, because this is, you know, the whole office gets involved in these kinds of things. I just want to make sure we aren't putting that employer in a position where this person can then go back and sue them. Because there was a man and a woman that applied for this job and they chose the man and not the woman. So can she come back and say, you're discriminating against me because I'm in a protected class? And when it's really, I just don't want you in this office anymore. I mean, this is an employer with 5 employees, 6 employees. I'm gonna have to work with you every day. And that's what I'm trying to find that balance.
And I think you've heard from different voices and perspectives on that.
And I would just add, I think you might want to consider that there are no cases, especially because these kind of agreements exist. And so if you take away that option, maybe there'd be more cases.
It may be.
That would be a concern.
Thanks, Bill. We do have to.
So Bill,
I spoke, I was getting out of the chair.
Yeah. No, I appreciate that.
before you leave, I want to know what
Gotta go to the
percent,
hard chairs now.
what percent of your members are unionized and what percent have
Oh, I have
gone?
no idea.
Okay, I would appreciate knowing that because my guess is a significant percent are unionized.
I feel the opposite.
Compared to other sectors maybe, but not necessarily an absolute.
Maybe email that. Thanks,
It would be
Bill.
helpful given
Okay.
Yeah, I'll follow up.
your
Bill,
position.
Thank you so much for your patience. We are on S102. We've now been discussing it, so this that's.
Okay.
Right.
Now,
Right.
switching gears.
We, wanted to make sure migrant justice was heard on the entire bill, particularly, we have one person who identifies as a farm worker come in and speak to this bill fully and the section on organizing for domestic and agricultural workers. We haven't heard much else, but you can go anywhere in the bill and share your organization's perspective.
Yeah, thank you very much, Chairwoman. I appreciate the invitation to be here. And thank you to the committee. My name is Will Lambeck with the organization Migrant Justice. We're here to speak in support of S102. Migrant Justice, as many of you know, is an organization founded and led by immigrant farm workers based in Vermont, organizing over the past 13 years now for human rights and economic justice. We know many of you, you've seen us in the State House over the years, bills around expanding access to driver's licenses, fair and impartial policing policies, equitable COVID relief, expanding healthcare to immigrants, and prohibiting ICE arrests in Vermont courthouses. You may be less familiar with our work outside the building, where principally we are organizing with dairy workers to improve labor and housing conditions in the industry. So I want to speak in support of the bill. I know that this contains several provisions which we're in support of. Protections for employee exercise of free speech rights, majority sign up. You've heard from others testify. I think Liz is going after me. They know those elements much better than I do, and so I won't spend time on them. We're also in support of extending collective bargaining rights to agricultural and domestic workers, and you've heard lots of testimony on the racist origins of these exclusions. Really see this is just the right thing to do. This is a no-brainer. Agricultural and domestic workers should be treated like any other workers in this respect. I wanted to focus the majority of my testimony on an element of the bill that I have learned has been taken out, the good cause provision. I understand it's not in the bill as amended, and there are strategic decisions around that in order to allow other provisions to go forward. We understand that, but I do hope that this is an issue that the committee takes back up shortly, because I see good cause protections for Vermont workers as vitally important, and I think migrant justice is a very unique perspective to share about this that we'd like to take the opportunity to share today. These provisions are necessary for workers in Vermont, and so I want to start by sharing a couple examples of farm worker testimony about experiences in this state very recently with unjust firings. I'll start by reading a testimony from a farm worker named Miguel, who until recently was working on a farm in Addison County. He says, "I work 12 to 15 hours a day milking cows, feeding calves, and cleaning stalls with only 30 minutes of a break. I was working milking cows one night when we heard that some people from the church that bring food and other supplies arrived at the farm. My coworker asked me to go to tell them that we couldn't see them while working. While I started to talk to them, my employer came and started yelling and was very upset. He pushed the person from the church and he shook and pushed me too. I don't speak English, so I couldn't understand what he was saying, but he was angry. He was yelling at us. The person from the church called the police because he had been assaulted. When the police arrived, they thought it was a fight between me and the church person. And because we weren't injured, the police didn't do anything about it. My boss told the police that he had already told workers that visits to the workplace weren't allowed, and that's why he got upset. I felt sad and confused about being yelled at, shaken, and shoved by my boss. When I just had started to work there, I had heard that he was a boss that would yell at workers, and that he had already kicked out another worker using physical violence. When this happened to me, I couldn't understand why he felt empowered to do so. It's unfair. I came to work, not to get into any trouble. I was fired 3 days after the incident. I think my boss waited for Monday to fire me because he doesn't come during the weekend. Violence and threats shouldn't happen anywhere. I don't want this to happen to anyone else, and I hope to stop feeling sad and afraid. I'd like to share another testimony from a worker named Maricela, or Mari. She says, "My name is Mari, and I've worked on dairy farms for the last 5 years. I came here to give my children a better life. During my time as a farm worker, I've been discriminated against and harassed. As a woman, it's hard to face this inequality. I've worked 60-hour weeks in the cold for far less than minimum wage. I've worked on different farms, some better than others. The last farm I was on, the worst of them all. I worked on the farm alongside my son and my then partner. My partner, who was a supervisor at the farm, was a violent man. One day he beat me. I was scared and I stayed silent. When he beat me again the next day, my son defended me by calling the police. When the police came for him, my boss didn't ask how I was. She just wanted to know who had called the police. When she learned it was my son, she fired him right there. My boss was furious with me, even though I was the victim. 2 days later, she fired me too. She ran me off the farm, throwing my final paycheck in my face. I asked for help, but there was nowhere to turn because there aren't any policies that protect us. Nobody can say that everything is all right in the dairy industry. We need change. Women are an important part of the industry. We also work to keep farms running and sustain the industry." So these are two examples of unjust firings that happen in the context of other severe abuse against workers. Unjust firings are a common practice in the dairy industry, as they are in many economic sectors. And we saw this increase over the course of the pandemic. Many workers were fired for asking for time off due to COVID or for presenting the symptoms. In one case, a worker named Ulver, when he told his boss that he had COVID symptoms and then he needed time off in order to get a PCR test, she responded, and I'm quoting a text message now, "You have 24 hours to find a new place to live. You can't pull that shit anymore. You're out. I'm sick of it." This worker and his pregnant partner were threatened with the police and were run off the farm, leaving them COVID positive without any personal belongings, a place to live, or the final wages that they were owed. So we see time and again unjust firings being used by employers to keep workers from advocating for improvements in labor conditions, or to keep workers from denouncing serious and unlawful abuse. Good cause would be one of the most important protections that could be extended to workers that could undergird and make enforceable other labor protections. Because without any protection against termination, those elements of labor law are nearly impossible to enforce, at least for the community of workers. But I'm also here to talk about an alternative, because the dairy industry in Vermont today is not just a story of unmitigated abuse and rights violations. In 2018, Migrant Justice created the Milk with Dignity program. Milk with Dignity is a supply chain human rights program that operates by signing binding contracts with buyers of dairy products that require them to purchase from farms that are enrolled in the Milk with Dignity program. This means that those farms must agree to abide by a farm worker authored code of conduct, and in return, those farms receive a premium from the brand or the company that purchases their products. The program currently operates in about 20% of Vermont's dairy industry, protecting more than 200 workers. Through this program, millions of dollars have been paid in premiums that have been invested in farm worker raises, health and safety improvements, new benefits like paid vacation, sick days, and holidays, and housing improvements and new housing construction as well. We've seen tremendous transformation on the 50 or so farms that are enrolled in the Dignity program. One of the protections that this program has is a just cause or good cause provision that prevents farms from disciplining or firing workers without good cause. It requires farms to institute progressive disciplinary procedures. This provision is not easy to enforce. Employers feel very entitled to terminate without good cause. The program's enforcement body, the Milk with Dignity Standards Council, was recently on the phone with an employer after a worker had been terminated without good cause, and they were advocating for that worker's reinstatement. And she, here's a quote, she screaming at them, said, I want to be able to fire whoever I want when I want to. And then she then referred to the program as the Mexican mafia, implying that she was being extorted by the program's enforcement mechanisms to retain a worker that she otherwise would have fired. So while it is difficult to enforce, and while there's a lot of resistance on the part of employers, the protections of the program do work and have been remarkably effective in ensuring that workers feel protected to raise their voice, to speak out against abuse, and to become frontline defenders for their own human rights. And what we've seen is that this institution of good cause protections, progressive discipline, have improved labor relations for employers as well, despite the real reticence and resistance. On farms where this has been implemented, we see clear communication between workers and employers. Workers are more likely to communicate when, for example, a cow falls during their shift or machinery isn't working, because they aren't concerned that they could be held responsible unjustly and be fired or disciplined. Employers then communicate with workers about mistakes and poor performance, giving workers the opportunity to grow in their positions. This means a higher retention of skilled and experienced employees. And this hasn't limited farms' ability to terminate employees when they do have good cause. Workers are still fired under the program when employers have cause to do so. Based on the experience of migrant justice, our knowledge of conditions outside the Milk with Dignity program and the real toll that unjust firings take, and based on our experience on dozens of farms with hundreds of workers who have good cause protections, we really see that this is a protection that should be extended to all Vermonters, and we hope to see the committee take it up again in the future.
Thanks, Senator Clarkson.
Well, thank you. I'm just curious, because we're not dealing with good cause, it's,
This week.
this week, and the House, the House has full time to hopefully address this. I am interested, because this bill does deal with collective bargaining rights for agricultural workers. How many farms have already negotiated bargaining rights and are unionized? How many of the migrant? I assume none of the migrant workers are unionized. I would make that as, I assume that, but I may be wrong. And so I'd just like to ask, how many farms are unionized, and what's the where would migrant workers fit in that? Because I'm not, that's it.
To our knowledge, no farm workers in Vermont are unionized because of exemptions.
Right, they don't have
under the law. They don't have the legal right.
And this bill would enable them to
It sounds
actually
like
find
Milk
that.
with Dignity gives them some of the
Exactly.
standards that they might
So
expect.
are you viewing this as an extension, really, of our Milk with Dignity program?
We see the two things working in parallel with similar aims. If farm workers were granted the right to organize and collectively bargain under Vermont state law, we would hope that many of them would avail themselves of that right. Farm workers currently protected by the Milk with Dignity program would also be able to organize on their farm and create collective bargaining rights that could exist in parallel to the protections that the program provides.
So I guess my question is there any, I would assume there were barriers for the migrant community to organizing, and I just because of their legal status for so many of them. Is that the case or not?
There are a range of barriers, and the current exemptions under the state labor law is one of them, but certainly it would still be difficult for many workers to form unions.
Because I just don't know, and this is maybe a question for Damien, is the legal status, whether, I don't know which has to be in place for there to be a union form. Do people have to be citizens? Is there a challenge here with migrant labor versus other ag labor in terms of setting a bargaining unit?
So there's, with respect to loss of employment laws, your status as an undocumented worker can be a challenge.
Yeah.
Because depending on courts that have held that undocumented workers are not entitled to the same rights
Yeah, that's what I'm
under the law.
basically.
So certainly when you're an undocumented worker, the challenges are significant just because of your legal status in the country. It's hard for me to say though whether how that would play out if the bargaining rights that are proposed in 102 move forward. I think we'd have to see how the court ruled on that or the labor board ruled on that first, because I think that would be step one.
Okay.
Go from there.
And we're gonna have, I think other people are taking note, who are gonna testify later as well.
Yeah, no, I just think it's an
Come up with
interesting
building
aspect of
trades.
this, is
Yeah.
that might be a possibility.
Other questions?
If we have time, so the Milk with Dignity, it seems like a kind of good experiment with, some of the protections that we're talking about. Where does the premium come from?
The premium is paid by companies that buy dairy products, and through the contract that they signed with Migrant Justice, they pay a premium to the suppliers or the farms in their supply chain that they're buying from.
And that's voluntary. So is the idea that customers see the Milk with Dignity emblem and are willing to pay more for it?
It wouldn't necessarily translate into a price hike for the consumer. The premium could be a cost that a company decides to pay. They could pass it along to the consumer, but that wouldn't necessarily be the case.
Okay.
But certainly consumer demand for products that are produced under dignified conditions is a part of why companies.
Like our B corporation.
Well, it comes out of, I'm familiar with Immokalee, Florida, because my daughter worked there. But I think Immokalee was one of the first, rather than it's tomatoes, I believe, in Florida, that were done by slave labor. They went to McDonald's and other chains that bought the tomatoes and said, look, do you want the public to know that the tomatoes on your Big Mac are being produced by labor, and we want you to guarantee to put pressure on your supplier. And I think that's been proven to work, that the suppliers don't, Ben and Jerry's doesn't know what's going on. And they're one that signed on, that what's going on in the farms. And yes, illegal immigrants are, you go to complain and you're illegal, and the risk is you're going back. And so they're really outside of the law, and this is having some effect here.
Senator Brock.
Just a question, it's a little bit off what's in the bill, but during one of the examples you mentioned an employee who did not make the minimum wage. And I know that agricultural employees are exempt from Vermont's minimum wage law, but the Fair Labor Standards Act has a certain floor. And I'm just wondering what your experience is of your workers, particularly working on larger farms relative to minimum wage and the federal staff standards.
That's right. Yeah. In this case, the worker was referring to the state minimum wage, from which the farm is legally exempt from paying. About half of farm workers in our membership are making below the state minimum wage, or more than half. The Milk with Dignity program requires farms to pay the state minimum wage for the jurisdiction in which they operate. And you're right, the Fair Labor Standards Act for farms over a certain size, 500 man hours, are required to pay the federal minimum wage, which in our experience, most farms do.
Overall, on average, what are farm workers that are members of your organization being paid?
We would say that the median is probably slightly lower than the current state minimum wage, probably in the region of $12.
Okay, but that would put him above the federal, definitely.
But and overtime, I assume, is not never.
That's correct. Yeah. No, okay.
Because in the average work week,
60 to 80 hours.
Senator Bergstein.
So I'm just, while we're, because all these bills are dealing, one thing that's concerned this committee and concerns many of us in the State House is the New York Times article about underage ag workers, the abuse of child labor laws. And that is a question, I think, for you. Where are you and what is, can you give us an update on where we are with that and how many farms do we see that happening on?
Yeah, and I would like the opportunity to come back and talk about that again in the future. And actually, one of the reasons I'm rushing is I have a call with Congresswoman Balance right now to talk about that very issue, and that they're waiting on me. But briefly, I would say it's a complex issue, and I think somewhat more complex than what was presented in the New York Times article. As with minimum wage and overtime, there are agricultural exemptions to child labor law as well. So 16, 17-year-olds can work on farms without restrictions, and that is quite commonplace throughout the dairy industry. Workers under 16 can also work with restrictions around hours and the type of work that they do. That is less common, but also does happen. It's our position that Ben and Jerry was named in the article, and that creates a misimpression that they're particularly culpable, when in fact they were brought to the attention in the New York Times by Migrant Justice to show that here's an example of a company that has taken a positive step in creating binding enforcement within their supply chain to address this issue.
Great. That's really helpful. Thanks so much, Will. This has been really helpful, and I appreciate, we have limited time, but it's really important to remember, that our work will continue after this bill on other labor issues.
Good.
Thank you very much. I appreciate that. And I would love to come back in to talk more about that last question.
Yeah, no, it's an
Yes.
issue we've been
All of the above.
concerned about.
Yeah,
Thank you.
absolutely. Thank you very much.
Yeah. I just want to pause and ask Catherine and Peter how great your time constraint is. We are running a bit behind, lots of labor issues crossover week.
Thanks, Will. Good luck.
I'm okay. You're okay. Peter, are you okay?
Yes, I'm quite flexible today.
Okay. We will get to you shortly, but I don't want to shortchange Liz and Matthew.
All right, thank you. Yep, no
Yes.
worries.
And for the committee, I think we'll get through everything today. It's just a little more fuzzy about when.
By noon.
Yes, definitely. I mean, we have flexibility in the next hour, but we've had some time issues. Yeah.
Well, thank you so much for giving me this opportunity again to speak about this historic bill. Again, my name is Liz Medina, and I am the Executive Director of the Vermont State Labor Council, AFL-CIO, which is our state's federation of labor unions. We are part of a coalition of over 22 union, locals, and allied organizations supporting this bill, the coalition to pass the Vermont PRO Act, S102, which we are informally calling, as you know, the Vermont Protect the Right to Organize, or PRO Act. So at the heart of this bill, it's about giving respect and dignity to workers. As one of my mentors and former Vermont labor organizer, Ellen David Friedman, once told me, and I'm paraphrasing here because we've had many conversations, and it's all about respect. The most basic principle of union organizing is respect, respect for yourself and respect for your coworkers, respect for the work you and your coworkers do, respect for you and your coworkers' humanity, respect for you and your coworkers' intelligence. S102 is about giving workers that dignity and respect. And almost every time a worker approaches me for help in forming a union with their coworkers, they tell me that their employer is always talking at them, that their employer doesn't want to hear what they have to say, that they are afraid of saying anything, let alone doing anything that could be construed as insubordinate, such as walking away when their employer starts talking about them on subjects that have nothing to do with their work. To take an example from an active union drive, where were you at the meeting? Were you at a union meeting the other night? Do you know how bad a union would be for the company? And on and on and on. Never mind that the employer is effectively implying that workers coming together to dare ask for better wages, benefits, or working conditions is inherently a bad thing. What can a worker who depends on their job to meet their basic needs do in a situation like that right now? The answer is nothing. S-102 corrects, in the words of NLRB General Counsel Jennifer Abruzzo, a fundamental misunderstanding of employers' speech rights, balancing employers' current absolute free speech with an acknowledgement that workers too have free speech rights. Importantly, Abruzzo points out the following. The board must keep in mind the basic inequality of bargaining power between individual employees and their employers, as well as employees' economic dependence on their employers. Over 75 years ago, the board recognized that the NLRA protects employees' right to listen, as well as their right to refrain from listening to employer speech concerning their exercise of their Section 7 rights. Forcing employees to listen to such employer speech under the threat of discipline, directly leveraging the employee's dependence on their jobs, plainly chills employees' protected right to refrain from listening to this speech in violation of Section 8A1. However, the board's Babcock and Wilcock case of 1948 threw out prior precedent which held that an employer violated the act when it held compulsory meetings concerning union representation. Abruzzo's understanding that Babcock and Wilcox was decided incorrectly may eventually prevail in correct course, but until then, states have the right to establish minimum working conditions and regulate activity touching upon deeply rooted local concerns. What Section 1 asks is for employers to treat their employees like free, intelligent human beings. It requires that workers not be treated as a collectivized object of speech, quote unquote, which, as Yale professor Charles Black eloquently wrote, is, quote, powerless to escape and powerless to answer. It merely frees workers from listening to very specific and unwanted political and religious speech. It is important to remember that employers would still be able to say whatever they want about whatever they want. The bill specifically prohibits employers from discriminating, disciplining, or terminating a worker who does not want to stay and hear coerced speech on religious or political matters. Again, as stated by former AFL-CIO General Counsel Craig Becker, with respect to Connecticut's Protecting Employee Freedom of Speech and Conscience Act, quote, states are permitted to adopt regulations even when they affect labor relations, when they address matters deeply rooted in local feeling and responsibility. This is because in these areas, there is an overriding state interest in the regulations. The state regulations that have been upheld on this ground typically protect personal dignity and private property. It should be further noted that political and religious matters are narrowly defined in Section 1 as, quote, matters relating to elections for political office, political parties, legislative proposals, proposals to change rules or regulations, and the decision to join or support any political party or political civic, community, fraternal, or labor organization, end quote. In case anyone was wondering, this would absolutely not apply to diversity, equity, and inclusion trainings. It's pretty clear in the language. If there is great concern still, we could add language such as, quote, nothing in this section shall be construed as a waiver of the employer's obligation to comply with Title VII Civil Rights Act 1964, though this should be rather obvious. Furthermore, to prevent these clear definitions from getting sticky, we would support removing Section 495A1 of the bill, which extends the section beyond the intent of this bill to include protection of, quote, the employee's exercise of a right guaranteed by the First Amendment of the U.S. Constitution or Chapter 1, Article 3, 13, or 20 of the Vermont Constitution, provided that the employee's exercise of that right does not substantially or materially interfere with the employee's job performance or the working relationship between the employee and the employer.
So
That's in the beginning.
Yes.
that's at the beginning of Section 3.
Yes.
No,
it's
Section 1.
495, Section 1, 495A1.
Oh, 495.
Yes.
Okay.
It has nothing to do with captive audience meetings. It was not part of the original language we suggested for the bill. We're not sure why it's there, and we would support its removal.
Okay, we merged 106 and 102 and then looked at like, what does that do? So, and that's why, but it's helpful to then say, is all of this gonna pass? So.
Yes, absolutely.
So you're supportive, just to clarify, the Section 1A1 one,
Yes, 495A1 in section 1.
but keeping two.
Yes,
And you're saying this because if there's a lot of what does this mean? And can somebody now come in a Confederate flag or whatever?
Yes.
You're not, that wasn't your intent. Your intent is to focus on the other pieces.
Correct.
Yeah.
absolutely. In a similar vein, section 3 of S102 corrects what is currently a frankly patronizing and infantilizing union recognition process. The current process asks workers to prove twice that they want a union. Actively signing up to join a union is not viewed as a worker making a clear and conscious choice. Our current process implies workers are not intelligent enough to make their own decision and need to be asked again, just to be sure. Those who purport to respect the freedom of choice should be appalled at our current union recognition process. Trust me, workers know both sides already, and workers are able to perfectly understand what they are doing the first time. In fact, many workers get the employer side from day one. I know that some Vermont employers show anti-union videos as part of their employees' orientation, videos that explicitly tell them not to join a union. A well-known example of these kinds of videos is Target's anti-union video, which went viral on John Oliver's Last Week Tonight show last year. In case it needs to be reiterated, section 3 would only apply to public sector workers. That it could potentially apply to private sector is wholly hypothetical, and our legislative council yesterday suggested that there really aren't any private employers to which section 3 would apply. Further, when it comes to union election integrity, majority sign-up or card check elections establishes a higher threshold than secret ballot elections because it requires 50% plus one of the full unit, whereas the secret ballot only requires 50% plus one of votes cast. In theory, you could have a secret ballot election where only 10% of the unit participates, and as long as a majority votes in favor of the unit will be certified. The argument that fewer employees would be able to weigh in doesn't hold water. Last, secret ballot union elections are not comparable to secret ballot political elections. They usually take place at the worksite under the observation of the employer. The employer has far more access to employees in the lead up to the election. Comparing a union election to a political election is comparing apples and oranges. Under any standard of free and fair elections for democratic legitimacy, a union election would likely not qualify due to the far greater access an employer has to their employees than individual employees trying to form a union. All workers, in conclusion, regardless of which industry or sector they work in, deserve basic respect and dignity at the workplace, which includes freedom of conscience and respect of their right and choice to form a union with their coworkers. I urge you to support S102, the Vermont PRO Act. Thank you. And I have copies for you all.
That's great.
And sorry they look a little weird because of my printer.
Have you sent it to Scott digitally?
I did, and I have talking points as well.
Thank you.
Thank
Right.
you.
Thank you very
so
much.
Liz. Matthew, thanks for your.
Does anyone have any questions? Sorry.
Oh, yeah, right. No, and I'm like ready to.
I know, I'm like rushing through.
I think we're good for now.
Okay.
Yeah, I think there was lots of
Good
discussion about
clarification.
A1, so that was helpful
Yeah.
to.
Right, to all this other controversy that's arisen. Yeah, thanks, Liz. Matthew, hi.
Oh, sorry, there are two things here. Did you guys get both of
Oh, I
these?
just
Oh,
have
actually,
one.
no.
Sorry.
Thank you.
Hold on.
Hi, and I don't know if you've been before us, so if you want to introduce yourself for the record, but also tell us more about who you represent.
Sure, I have not. My name is Dr. Matthew Polk. I'm the president of the Vermont Staff Organization. We're an affiliate of the National Staff Organization, which is a union of people who advocate for the interests of workers across the United States,
Okay.
primarily in the public education sector, but also elsewhere. And I really want to thank you for the opportunity to meet with you today.
Can you just clear, is it like Staff United? Is this part of AFT or?
No,
is
we're
this a
an
completely
independent union.
Do you,
Yeah.
can
So
you
what's-
say how many members you have in Vermont and which? what's your
Yeah,
clinical
so we are a member of union staffers. So all of us
Okay.
here in Vermont actually work for Vermont NEA.
Hmm.
I'm not here as Vermont NEA. I'm here
Okay.
as my role is in those of us who are workers, and we're
Mhm.
because we're all almost all union members who work for unions. They were the largest union in the country that actually has no employees. We do all the work ourselves, and we represent workers. And here in Vermont, and my day job, I represent teachers and custodians and bus drivers and paraeducators and kitchen workers and those who serve people our children in schools and make it so that the rest of our society can run.
So, and what's the name of your union again?
The Vermont Staff Organization.
So it's STAFF, like staff.
Okay, we're staffers. Yep.
Okay.
It's good education for us.
VSO. Yeah. I'm happy to come talk to you. And I'm a former educator myself. I taught in the classroom for about 10 years out in Washington State. And, I really want to thank you for the opportunity to just come and speak about what I think is really important legislation. And, when I first moved to Vermont from the Pacific Northwest, I was profoundly impressed with the commitment that Vermonters have to the principles of democracy. And it's something that I've admired about people across the political spectrum. I think when outsiders come to Vermont, they see Phil Scott, they see Bernie Sanders, and I think, what the heck is going on here? It's an unusual but special place. So, whether Republicans or Democrats or progressives or independents, irrespective of partisan persuasions, the citizens of this state understand the importance of seeking out the voice of the people and acting on the will of the majority to make decisions rather than allowing just privilege and power to dominate. And if you've never lived outside of New England, you may be surprised to realize just how unique these systems of democracy are compared to the rest of the nation, and how special it is, particularly here in Vermont, that so many possibilities exist for civic engagement at all levels of public life. For those of us who've made the Green Mountains our home, this opportunity for me to come and speak to you doesn't exist like this in most places. And it's a really special place. We have town meetings, we have local school boards that are our local schools are oftentimes the heart of our particularly small communities, and people have a say in it, whether it's passing the local budget or, speaking out about curriculum and matters of concern. And I remember first coming to this building, moving to Vermont, and seeing a quote on the wall about Vermont's commitment to freedom is the brave little state, and this brave little state now has a centuries-old tradition of leading the nation to promote democracy and equality by lifting up those who are just too often subject to oppression and exploitation. And, Vermont was a leader in ending slavery, in providing for the welfare of children through public education, in asserting that disenfranchisement is wrong, and insisting that marriage equality is right. And as the people's chosen representatives, you currently have an opportunity to enact our shared values and to further demonstrate just this longstanding commitment to democracy by passing what I think is important, but also very reasonable legislation. By passing modest protections for workers, you're helping to advance the principles of democracy now in the workplace and standing up for vulnerable members of society. By enacting this bill, we'll join a handful of states brave enough to lead the nation to stand up for the rights of working people who have few other allies. As a person in the labor movement, I hear from employers all the time, from other people say, well, who else is doing that? We don't necessarily want to be the first. And we've been brave enough to reject that kind of mindset in Vermont, to say, if it's the right thing to do, it doesn't matter who else is doing it. It's the right thing to do, and we're going to do it. And we should be proud of that. I want to say, I grew up in the eastern half of Washington State in the predominantly Hispanic community where agriculture was the driving industry. And many of the people who work the fields, pick the fruit, we get those Washington cherries in every once in a while. And I think Vermont's the only other place I've been to besides Washington has a great apple. And they process the food to feed the nation. And many of those folks, they exist on the margins of society and have little power to affect positive change for their lives. And in nearly any other industry, such workers would have the chance to organize together to bargain improvements in their workplaces around safety and wages, and to push back against the powerful interests who depend on their labor. And without the right to collectively bargain, these farm workers are left without almost any ability to pursue a better life. And we have the opportunity to change that by expanding collective bargaining rights, and we should. In response to a comment from earlier, there are no legal restrictions nationally on the ability of workers to join and participate in a union based on their documentation status. In the same way, employers aren't permitted to avoid like wage and hour laws simply because someone may not have legal paperwork to be here, right? You can't exploit people based on their legal status. But additionally, by enacting carb check rules, we're demonstrating our belief in democracy by acknowledging that the voices of workers should count, that should mean something. And in any other context, we could easily and heartily object to a system where people cast a vote or make their voice known on a subject, only to allow powerful interests multiple chances to intimidate them into changing their minds. Such a system is not just democratic, it's really patronizing and patriarchal in the worst kind of way. When a worker signs their name in support of joining a union, that opinion should count. But currently, it's just one step in a convoluted process that simply isn't necessary. And arguments about casting secret ballots we heard about earlier, it's just nonsensical. We have town meetings across the state where people engage in direct democracy through floor votes. And of course, decisions you make are no less democratic when they're made public. You're making a decision, that decision should count, and then everywhere else in our life, it does count. That said, what I really want to focus on is captive audience meetings. And what this legislation does is merely assert that work is for work. It's that simple. It's not for indoctrination to push the views of employers onto their workers. Neither is the workplace the proper place for proselytizing about religious views. Similarly, workplace is not the place for bosses to intimidate individuals looking to organize with other workers. And this bill certainly doesn't limit the free speech of employers who may want to discuss their issues. All it does is protect the right of people to go to work and allow them to choose to do their work. And there will be employers and other interest groups who are opposed to this. And they'll assert that it's wrong to place any sort of restrictions on their business or to treat their employees anything other than the way they want to. But this argument it doesn't hold water. Since the civil rights era, as a society, we've enacted reasonable regulations on the way that people interact with one another at work. And each time, certain employers have stated their opposition to rules that subject their employees to offensive speech. There was a time when it was perfectly acceptable for crude bosses to make demeaning comments and sexually harass the people that they manage who just want to come to work and do their jobs. Likewise, we've set expectations that it's not acceptable to discriminate against those in protected classes through the enactment of regulations that prohibit subjecting workers to like offensive racist speech, right? Expectations of this sort were put into law because we recognize that people should just be allowed to come to work and do their work. And just as we've told employers that they need to enact certain workplace expectations to protect working people, we also should acknowledge that mandatory captive audience meetings, which exist solely to subject workers to the personal beliefs of employers, need to be eliminated. I would propose they just be eliminated. But the captive audience provisions of this bill are really modest. They don't go that far. Employers are still free to hold any position they want. They can say any sort of nonsense they want. And all this bill does is provide working people the right to focus on their jobs without requirements to be forced to be subjected to the personal opinions of their employers. And, I want to be clear, it's no surprise, I'm not an unbiased party. I'm a union member whose life has vastly been improved because of my union membership. And I believe that our whole society is better off when workers have the right to join together, to exercise their voice, to participate in meaningfully negotiating the terms of the work. And by removing the ability of employers to discipline or terminate workers who just want to do their work, we're making for a better society. And when it comes to this captive audience provision, that's really what this is about, is to say, are we going to allow workers to just come to work and do their work free from harassment and protections to to live their lives as they see fit?
Thank you. Thanks so much, Matthew. I really appreciate all your patience and waiting to speak on behalf of a lot of staff workers around the state.
How many people, because you asked that question. And
I represent here in Vermont about 20 people, and then
20, okay.
About 20 here in Vermont, and there's about 1,600 nationwide.
Okay.
And all of us here in Vermont are working under
the NEA.
Yep.
Okay.
You work under the NEA and for the union.
Yeah.
Themselves. So you're union.
A union for a union.
Union squared.
Yeah, there you go. There you go.
Thank you, Matthew.
Thank you.
I really appreciate it.
Know how many unionized workers there are in Vermont? I mean, I'm coming out of the Pittsburgh experience where
Yeah.
everybody was.
Right. Yeah, I mean, AFL-CIO has 11,000 or?
We have 13,500, and my estimate is around 33,000.
Okay.
Out of a workforce out of like almost 300,000.
Yeah, 312 roughly is.
Yeah.
So about
number of
10%.
workers.
This is not a union
Well,
state.
right. So it covers
We're about
between
the
11,
14th
12,
then.
10%, exactly.
Okay.
Okay, thanks so much, Matthew.
Thank you. Have a lovely day.
Really want to appreciate the patience of those who are waiting to, well, again, Catherine is a great segue from one topic to another because representing Bernie's office, it sounds like you're also able to take the witness chair and prepared to say something about this bill and then move on to sister state. What I have learned is that, and please take the witness chair, David Hall, our drafter, has to be somewhere at 11, so we'll have to move the vote on the bill to tomorrow, but we'll take the testimony on the sister state S30 today. So we'll start with Catherine, who's going to speak to both S102 and S30. Thanks, Damien. And Damien has answers to some of these questions that we'll also have to bring up tomorrow. We're going to revisit this 11 to noon, but I don't want to.
The NLRB.
Yeah, he's listening.
I think we need to.
Yeah, that's right. So you were so patient.
Good
Thank
job.
you for visiting.
No, she did.
I know.
She was incredible.
Yeah.
She was incredible.
She was.
Totally.
Catherine, thank you so much for your patience. Peter, thank you for your patience. We'll get to you soon as well.
Okay. For the community record, my name is Catherine Becker Van Heest. I'm State Director for Senator Bernie Sanders. Please feel free to call me Katie. I'm going to speak a little bit to start about the PRO Act that's being considered at the federal level, for some context about where we stand in America when it comes to workers' rights and how the PRO Act would help further those rights. Obviously, Senator Sanders is a tremendous supporter of the PRO Act and of the rights of workers to organize more generally. I thought I would start with just a few facts that might inform the current status of the situation of workers in this country and what it means to be part of a union. Today, 64% of union workers have defined benefit pension plans. That means that their income is guaranteed in their retirement. So that's 64% of unionized workers. For non-unionized workers, that number is just 11%. So there's a tremendous differential between the ability of non-union workers and unionized workers in their retirement to have a guaranteed income. Not only does that have an impact for the individual worker in their retirement, it also has a tremendous impact on our state government and overall economics. If we know that our workforce in their retirement has a guaranteed income, that has a tremendous impact on all of the other social safety net programs that the legislature here in Vermont looks to fund. Additionally, most employers do run anti-union campaigns. They're not always called that, but in reality, that's what happens. So in the private sector, 75% of employers hire outside consultants to run their anti-union activities. 90% force employees to attend closed-door anti-union meetings where they are subject to information, often incorrect information about what joining a union would mean for them. And 54%, I was actually struck by this myself, 54% of private sector work employers threaten their workers in one-on-one meetings. So not just these group captive audience meetings, but literally one-on-one. And you can imagine how intimidating that would be for a worker to be sat down one-on-one with their employer and told all of the negative reasons for what would happen if they joined the union. Nationally, so that sort of sets the stage for why the PRO Act remains so important. Nationally, what the PRO Act would do is it would enact first contract provisions to ensure companies cannot prevent unions from forming or denying a first contract. We still see, unfortunately, that even in our organized workplaces, once a group forms a union, there can also be long delays in getting to that first contract. And that's a real struggle that a lot of Vermonters still face. And we want to make that easier, but also for all new unions forming, we want to make sure that their employers cannot deny them the right to form that union or deny that first contract. The PRO Act would also permit unions and employers to agree on fair share fees to collect dues. And that would be even in so-called right to work states in the country, which is currently an issue. We don't face it here in Vermont, but in many other states we do. The PRO Act would also prevent the misclassification of workers as supervisors or as independent contractors that would prevent them from joining a union. And it would prohibit employers from using franchise or contract agreements, again, to avoid liability in unions. And it would ban the permanent replacement of striking workers so that if workers did choose to strike and enacted that right, they could not be permanently replaced. Another thing that the PRO Act does that I think is particularly important as it pertains to Vermont is that it would codify the so-called persuader rule under the Obama administration. And that rule requires employers to disclose agreements with consultants for anti-union campaigns. That's obviously something that takes place right here in Vermont. Employers will often hire consultants, law firms, et cetera, to help them wage anti-union campaigns. And I think as Vermonters, as legislators, we all deserve the right to know what those contracts look like, how much employers are paying those outside consultants, and how those outside consultants, many of whom are in the State House, are profiting from an anti-union environment. To sort of close out, I want to give a couple of statistics and also give an example in Vermont. One thing I think that's particularly important and sometimes missed when we talk about the rights of workers to form a union is not only the economic impact for the individual worker, but also how it helps to close the racial wage gap in employment. So we know that nationally, unionized workers see a wage that's 11% higher than their peers nationally. So that's, categorized in the same job, unionized versus non-unionized, there's an 11% increase for workers who are unionized. That grows though, when you look at specific racial characteristics. So for Black workers, it's not 11%, but it's 13.7%. So unionized workers who are Black have a 13.7% higher wage than their non-unionized peers. And for Hispanic workers, that's up to 20%. So it really helps, unionization can really help to not just raise wages for workers, but also close the wage gap.
And we have a bill on closing the racial wage gap as well.
And this sort of nicely pairs together.
And what about women? Do you have?
I don't have that statistic, but it's, I would
my guess is
presume similarly looked at, particularly when you look at some of the quote unquote traditional professions for women, teaching, nursing, et cetera, and how the wages are particularly increased for those who are unionized. I can try to look for the data for you on that though.
Okay, we'll pause on it. PROACT and take questions and then move.
Can I give you just
30.
one more
Yeah.
statistic and I'll be
Yeah.
fast? So this is just an example in Vermont. It's a small one, but I think it's important because sometimes I think of Vermont as immune to some of the anti-worker things that happen. We think about that as other states. So in May of 2021, 12 workers at Goodwill in Williston walked out to protest poor wages and poor working conditions. And 2 of those workers were fired, including a store manager who was not part of the walkout, but was blamed by their supervisor for failing to stop the walkout. If the PROACT had been in place when that happened, those workers would have been reinstated. They would have been able to recover back pay, and penalties would have been levied for the illegal firing of those employers. So I will stop there.
Thank you. Senator Clarkson.
So that's in the federal PROACT bill.
And
It would be that.
that's why we were,
protections,
we were mirroring some of that
Yeah.
language, which included good cause termination.
Which, sadly, good cause will be a little later in our discussion. Would you be kind enough to send us some of those statistics?
Yes,
Would be helpful.
absolutely.
And I guess I would ask, the federal PROACT has just been introduced, right? Its chances now of survival both through the Senate and the House, highly unlikely.
So probably for most bills you will hear me talk about in the
Right.
legislative session this year, my response will be similar. Unfortunately, the PROACT did pass the House of Representatives last Congress. We had really wished that the Senate would do the same and we would have been able to deliver it to President Biden's desk for signature. Unfortunately, that did not take place. The odds remain frankly pretty low to get to the president's desk, but that doesn't mean we're going to stop fighting for it.
Right? No, here. Good. Sadly, this session, this congressional session, it's beginning in the Senate and going to the House.
We do things like you can kind of start anywhere, so it doesn't really matter for us, but I would presume
The ball
dead
is
on
in the
arrival
Senate.
in the House.
The
So
ball is in the Senate.
essentially, yes.
Yeah, okay, great, thanks.
Any other questions for Katie and Bernie's office on?
Just one
this
question.
bill?
One of the statistics that you mentioned was a percent, I believe, of 51% of workers were threatened during the course of, I'm wondering if you have a source for that
Yes,
statistic.
yeah, it's 54%, and I'll get you the
Yes,
specific
good.
information,
Thank you.
absolutely.
And that's national.
Correct, that's national.
Any other questions?
What, can you define threat? Like things would be really bad or like you're gonna get fired?
Yeah, that's defined in the source material, so
Okay.
I'll get that for you.
Okay.
I could get the range of,
Yeah, I figured it's probably.
Yeah,
Let me go first.
I would love that. We were just conferring because I don't want to walk out on any one single witness. I really have to use the bathroom.
Fair enough.
So we can continue to ask questions about this or move to S30.
Sure, we're ready.
Yes, we've been sitting here since 8, and so.
No problem.
We're
And
we're
drinking
all in.
coffee.
I support leg stretching, bathroom use.
I was thinking of offering an amendment to require this committee to unionize so that we can get breaks.
We could organize for that effect. Do we have any other questions right now
I'm
on,
good. And I
on
appreciate
102? Okay, great. Well, good luck.
Thank you.
And why don't we shift at the moment now to S30 to the sister state legislation, which.
The Department of Labor says 23% is the female wage differential.
Thank you.
Oh, thank you. That is super helpful.
The United States Department.
That's the national.
Now I
That's
don't
great.
have to sit here and Google it. when we're done.
Yeah. Thank you very much, Matthew.
I know.
That's great. That is what I figured it was going to be higher, and it was a lot higher.
Thank you all.
Thank you,
I'm
Liz.
just gonna stand up. I'm still
Yeah,
here.
no, I think that's.
You all just are lucky enough that the pro tem call you out so you can say.
Okay. Are we able to shift gears from our union work to our international partnering with other communities? So we're going to do a whiplash from domestic issues to international issues, and that have local and domestic repercussions. So let's shift to S30, an act relating to creating a sister state program, which we have had in the past and which we are interested in pursuing. And you have some thoughts on this, Kate,
I do. I have some limited thought. I also don't need to go first, so I don't know if other people have.
Well,
time.
you're there.
I
so-
am
And
here.
there is, are you testifying? No, he is just taking notes.
Maybe we have
And so
some-
we have Peter on deck and we have Patricia and we have no David Hall. So, great. Why don't you start? You're in the witness chair and you may have other things that you need to go and do.
And I will be
Oh,
relatively.
thank you, sir. Is
quick.
this a new draft? No, this is
No,
as,
so I
in- do
wasn't sure if anybody, people
you want
have-
it as introduced? Great, terrific.
It's, I'm sure somewhere in the file.
Probably, but I figured.
No, this is great to have it fresh at the top of the file. Thank you. So Katie, why don't you start it up?
Fantastic. Do you need me to reintroduce myself or are we? good?
No,
Okay.
we all know who you are.
Great. I'm going to be pretty brief on this. So just for everyone's situational awareness, I think most of you are familiar with this, but typically as a Senate office, we don't take a position on any particular legislation that is being considered before the Vermont legislature, but we are happy on almost all occasions to provide either a federal perspective or the senator's perspective on the policies in general that are being considered. So that's kind of where my comments today sit.
We've shifted to international.
Okay, I couldn't tell. It's a very blank
Well, she
statement.
just-
It does apply to all, so it kind of works. So I think just in terms of some perspective around the sister state consideration, I think probably most people are familiar with the fact that as mayor in 1988, then Mayor Sanders, now Senator Sanders, started a sister city program with Yaroslavl in the then Soviet Union. And that was a program where cultural exchange took place between the city of Burlington and the residents of Yaroslavl. While that came under some scrutiny, I guess, during the senator's presidential campaigns and other times when that was looked at because of Yaroslavl's location within the USSR, it's interesting to note that that was actually a program that was stood up under President Reagan, and it was done intentionally to build relationships between the United States and the USSR. And since then, the now senator has been very supportive of these types of relationships. He sees cultural exchange as an incredibly important part of what we do, that it has incredibly valuable perspectives that it can provide citizens, both adults and young people. One of the things that we work on in our office with great partners across the state of Vermont is opportunities for cultural exchange for our students. We are regularly looking for opportunities for our young people to engage with folks in other parts of the world, other countries where they can learn things beyond how we do things here in the United States, but gain perspectives on the ways that other cultures, other communities, other countries run their governments, but also interact, how they deal with things like the threats of climate change, how they pay for healthcare. It's really, we think, important. And also beyond the policies and things that young people can learn, in general, these sister programs can provide just a real opportunity for cultures to engage with each other, find common ground, and at the end of the day, usually see how similar we are.
Great.
Any questions?
No, I have a spouse who was very involved with the Vermont Law School, and the Vermont sister state with Petrozavodsk and, all the work that we did there. And it was great. It was I'm really sorry that we pulled it.
I'm going to say out loud, I do think this is a relatively benign bill. So I don't.
Yeah, I mean, I don't.
My children went to Siberia.
There you go. Travel is good, person to person.
Actually, two of them went, one went to Karelia.
Yeah,
One went on
Karelia,
an exchange, then went back to Siberia as part of his college program. And we had the ballet master from Petrozavodsk stay with us over Christmas, along with one of the dancers. And then we had three girls one summer for 2 weeks, I think. The only word I knew they said was magasin, and that's French, and I knew they wanted to go shopping. We did very well.
And so we've all experienced our partnership with Karelia.
Yes, Erica taught basket weaving in Karelia. Why? When she was a Potter, I don't know.
Senator Brock, did you want to say?
It's just only thing, in the back of my mind, I always have to question about due diligence. Because there's some places you probably don't want to be sister cities with. We don't have a process. I mean, unless we add foreign relations to economic development, housing, foreign relations and general affairs, and have some sort of a mechanism. I don't know in terms of when we start a sister state relationship, does anybody do anything to at least give us some assurance that we're not.
That's exactly what the bill is about. And David can make sure we go through the language in case you want to strengthen anything, but it's saying it's been too ad hoc and we should set 5 up and phase 1 out if we want another one, and, you know, be really clear that this isn't just like, they don't point to somebody at ACCD and say, figure this one out. So it is better when it's really intentional.
And if I can, I would offer for the committee as well, that if our office can serve as a resource to help with any collaborations with the State Department that might be needed for the vetting of a particular location.
That might be very helpful.
Happy to play that role.
Yeah, or if there are criteria.
Yeah,
and overall goals.
Yes, so some of us got called on a resolution that was put in about taking a side and some.
The Greek Orthodox?
No, this was an island in the Pacific, and we were actually voting. I know some of us have been to Taiwan, and they stay very closely in touch with us about things they might like, but all I'm getting is their side of the story. And before you do a resolution.
Right, or where money comes from when someone travels, that's all really important. Great, thanks so much, Katie. Thanks for being here an extra amount of time, and hopefully it was good for the Senator's office to hear people on the ground talk about labor issues.
Yes, it very much was, and I appreciate your time, and it worked out perfectly to do 1 too. So thank you.
Okay, thank you. Patricia, unless Peter, if you're still flexible, we'll go to Patricia on just next on the list, but we really appreciate your patience and waiting for so long.
Perfect. Thank you so much. And thank you, Senator Ram Hinsdale, for inviting me here today and to the whole committee. My name is Patricia Preston, and I'm the president and CEO of the Vermont Council on World Affairs. And I'll start by saying I'm so glad to hear there's hosts in the room, because we're always looking. So we do have plenty of people that would love to stay with you. And also, these aren't part of my formal remarks, but our organization actually does work with the State Department, and they continually are vetting the list of folks that we can partner with and can't partner with. And we have regular access to those lists if that would be anything that is valuable as this committee proceeds. But so I'm really grateful to be joined here today in support of Bill S30. Sister state programs like sister city programs and programs run through the organization I lead, the Vermont Council on World Affairs, they lend themselves to international exchange and public programming, which enables Vermont businesses, organizations, and community members to experience firsthand how shared knowledge and expertise and cultural connections can forge lasting business and cultural relations between Vermont and leaders and learners, as we call them, from around the globe. And I've seen firsthand how our exchange programs provide mutually beneficial access to leaders and decision makers and subject experts, as well as critical opportunities for the cross-cultural connections you all were just discussing, you have individually experienced. And in fact, we have a group that we're currently hosting. It's a Ukrainian delegation in Vermont right now. And this group is composed of 5 medical professionals whose work focuses on transplantation and the ICU. And they're visiting labs, they're actually at a lab at UVM right now, and other medical facilities where they're learning from pathology to oncology and transplantation and ICU and other emergency medicine experts. They're also visiting companies like Beta Technologies, who are also working to advance innovation and healthcare access. And I think some of you may have even seen them walking around the State House yesterday as they're learning about our democratic practices as well. And they will take all of these things they've learned back to their home country, which is in a lot of need right now. And this program is actually similar to, we work with Yaroslavl, which was just mentioned. And that program, the Yaroslavl program we work with, we partner often with the Sister City program, or we did previously when we were still working in Yaroslavl. But this program that we work in has hosted more than 30,000 current and future leaders from post-Soviet area countries and have participated in this particular program called Open World, which we run. And it is the most effective US exchange program to promote mutually beneficial options to depolarize engagement between future national leaders. And it's a unique but no less powerful tool for Congress to engage legislatures in critical regions of the world. Citizens from around the world have participated in the Vermont Council's exchange programs, similar to the Open World program, and they've stayed in the homes of Vermonters, building meaningful relationships that humanize and connect people across borders and cultures, giving the heightened geopolitical rivalries we see today, public diplomacy at all levels, which is vital to advance diplomatic relations. So sister state relationships have the potential to engage in work similar to the Vermont Council on World Affairs, where we have seen the growing impact of exchanges and people-to-people diplomacy in Vermont for over 7 decades, where we've been bridging divisions, fostering a greater understanding of the world and its people, and creating mutual respect for diversity of thought, while simultaneously pulling millions back into the Vermont economy. And the examples of this are honestly endless. And I would give one more, if I may. It's last week, we hosted a group of 18 delegates from across Europe to engage with folks in Vermont who collaborated to find solutions for an inclusive approach to climate policy. And our role was to facilitate opportunities and partnerships between private businesses, nonprofit organizations, and international leaders that resulted in a sharing of ideas and the development of best practices. Programs like this leave our private and public sectors stronger than ever. So I think that the opportunity within a sister state program is vast and has the potential to do the similarly impactful work we're currently doing at the Vermont Council. And I stand here today in solidarity with those working to advance people-to-people diplomacy. This is a critical opportunity for Vermont to strengthen the economy and the cultural fabric of our state. So thank you for having the opportunity to come in and speak with you about this today.
Thanks, Patricia.
Yeah.
And thanks for the work you do at CWA. Any questions? Okay, we're rocking and rolling. Thanks, Patricia. You're welcome to stay for Peter's remarks or leave as you need to. Peter, thanks so much for your patience. And I'll add my story now, which is I went to Japan with the US-Japan Council with the late Irene Hirano Inoue, the wife of the late Senator Daniel Inoue, and she became a great mentor and friend, and Japan is just wonderful. So I'm probably, full disclosure, the most excited about the possibility of traveling to our sister state in Japan.
Yeah, because my daughter went to Japan, but but that was because she had roommates from Japan.
Oh, nice. Yeah.
So she went to visit them.
There are a lot of similarities, I think, between Vermont and Japan. And in Japan, they have something called Vermont curry. That's maple apple curry. And it's like one of the staples of the diet.
We had cabbage pancakes and maple syrup is sauce.
Yes. Hi, Peter. Thanks again for your immense patience, and we're excited to hear what you have to offer.
Hello, greetings. Thank you. Yeah, that's so funny. When I'm in Tottori Prefecture in Japan and asked where am I from in the United States, I say Vermont, I get a blank stare, and then I say like Vermonto curry, and they say, oh yeah, okay, we know where you're from now. So there is this curry product that has apple and honey flavor to it that is named after Vermont, which might be a violation of our labeling laws, but there it is. So I'm Peter Lynch. I'm the director of Green Across the World. We're a small organization and has for over 2 decades focused on culture and environment. And the environmental part is kind of writ large. Our exchanges are reciprocal. In other words, we encourage travel to a foreign partner as well as hosting here. when we do host here, our programs typically involve some culture and history, but also natural history, opportunities to get in the field with field scientists, opportunities to visit businesses and see what what does good natural resource management mean to our businesses and our agriculture and our silviculture. And as Patricia just suggested, we also will bring them to the State House and we focus particularly on, the environmental natural resources committee, but we look at our political process here. Much of what needs to be said has already been said about the value of these exchanges. I did notice the pivot from labor to international relations, and I would argue they're not entirely unrelated. When we look at the economic aspect of international exchange, it helps employers understand where some of their immigrant labor is coming from. I also appreciate your question, Senator Brock, about oversight. And I think that really is a large part of the motive for this bill, is to provide a system where there is some regular oversight, where the state can, if a certain relationship becomes problematic and perhaps even unsafe for Vermonters, that we can pull the plug on it. And there's language in there that allows for that. It also sensibly limits the relationships to 5. We're a small state. Mary Nietzsche, who's the director of international relations for the state of Maryland, told me that they have 40 years of sister state programs that now include 18. And she said that's simply too many, even for a state like Maryland. It's too many. So the other part I appreciate is the idea that initially a sister state relationship has 8 years to get off the ground. You'll hear in a video that I'm about to play that relations between Vermont and Tottori, Japan have been building for a good 20 years, starting with a meeting between then Vice Governor Hirai in Tottori and Governor Howard Dean, led to a signing of a sister state agreement. What was it? Oh, a sister friend agreement between Governor Douglas and Hirai Chiji had graduated to the governor of Tottori at that point, 2008. Then 2018, Governor Scott and Governor Hirai signed an actual sister state agreement between the two regions. So this has evolved from that work. Somebody mentioned Karelia. That was as far as I know, the only other sister state relationship at the state level. We have lots of sister city and other relationships scattered throughout the state. And I'd hope that this, this committee would provide some sort of coordination, oversight, support. It sounds like Senator Sanders' office would be happy to contribute to that support. To make, in the end, to make the whole experience more sensible and coordinated and thoughtful for the state of Vermont. So perhaps what I'll do is share this video, but first I want to tell one, Patricia and I have been doing this sort of work for a long time. I'm a long-time educator. I started in public school science and moved into this informal education. But an example that I think kind of captures a lot of what can happen in this work is that we were it's over 10 years ago now, hosting Chinese students from South China in Vermont for a summer program. And 2 of the Chinese girls and a girl from Jericho, Vermont, worked in partnership to try to understand the biology and the possibilities for exportation of 3 different invasive species in Vermont. One of them was purple loosestrife, and the Chinese students recognized it immediately and said, "Oh, that's a native plant where we're from." And they said, you know, it's valued there for its qualities as a medicinal tea. So they said, why don't you, if you're extracting purple loosestrife here in Vermont, trying to limit its spread, why not, instead of just composting it, dry it and prepare it as a tea and market it in Chinatowns in Montreal and Boston and New York, and create a revenue stream? Well, that's a really interesting idea. I mean, an American team of students simply would not have thought of that on their own. And it crosses between cultural understanding and recognition and values and economics. So I submit that this sister state committee will actually offer a lot to, in addition to the quality of life and worldview and understanding of our people, it can also contribute economically. And Patricia also mentioned that the economic value to the state. So this is, most of what you folks look at, like the labor relations issue and housing, are front and center in immediate needs. This is something that it takes time. The return on investment does come, but it comes slowly. But that return on investment can be exceptionally high. So I certainly hope that, hope that this moves through the political process in Montpelier, and would very much like to support this bill pretty much as written. So what I'd like to do, if I can take up another 3 or 4 minutes of your time, is simply let one of our foreign partners speak. So I'm going to set up screen share here, and we'll hear from Tottori Prefecture in Japan. Let's see. Here we go. So you should now see. Are you able to see what's on my screen?
Well, barely. It's very black.
It's not started. It hasn't started yet. I just want to make sure. Okay, if it's very black, that's perfect.
Yeah, we're good.
今年、バーモント州との姉妹提携5周年を迎える日本国鳥取県から、この度の姉妹交流制度設置にかかる法案成立に期待を込めて一言申し上げます。
As Tottori Prefecture prepares to celebrate its 50th sister state anniversary with Vermont, I would like to express my sincere support towards the bill to officially establish a sister state program.
当県とバーモント州との交流は20年以上の歴史があり、2008年の国際親善に関する覚書締結以降、青少年交流や大学間の学術交流を中心に交流を深めてまいりました。
Tottori Prefecture and Vermont have a history going back over 20 years. And ever since we signed our friendship agreement in 2008, both regions have endeavored to deepen relations through exchange activities involving youth groups and universities.
そして2018年の姉妹提携を契機に、教育やスポーツ、商業、文化芸術など、より幅広い分野においても交流を発展させるべく、両地域が連携して取り組んでいるところです。
Furthermore, since our sister state relationship was recognized in 2018, both regions have worked together to develop exchanges in a wider range of fields, including education, sports, business, culture, and the arts.
姉妹交流が両地域にもたらしたかけがえのない成果は、国際的視野に富んだ青少年の育成であり、両地域から輩出した人材はさまざまな分野で活躍し、地域社会の発展に寄与しています。
The irreplaceable results that this sisterhood partnership has brought to both regions has included the fostering of generations of young people with a rich international outlook and the participation of many people active in various fields who have created and contribute to a strong local community.
また、コロナ禍という未曾有の危機を共に乗り越え、絆を深めた両地域は、今後も経済や文化芸術等の幅広い交流を通じて、互いに反映していくものと考えています。
In addition, we believe that both regions, which have only strengthened their ties during the COVID-19 pandemic, will continue to prosper together through wide-ranging exchanges in economic and cultural areas.
当県では、今年、姉妹提携5周年を記念して、バーモント州への訪問団の派遣を計画しております。本法案成立の暁には、現地で関係者の皆様と喜びを分かち合えることを期待しております。
To commemorate the 5th anniversary of our sisterhood relationship this year, Tottori Prefecture intends to send a delegation to Vermont. If this bill is enacted, we hope to share the joy with everyone in Vermont.
最後になりましたが、本法案の成立により、当県をはじめとするバーモント州の姉妹交流が一層発展することを心より祈念いたします。
Last but not least, I sincerely hope that the enactment of this bill will lead to the further development of sisterhood relationships in Vermont, including our prefecture.
Wonderful. Thank you, Peter.
Well, yeah, thank you so much. It's final note, we are sending 4 students from Burlington and 4 from Essex to Tottori in April this year. So finally, COVID's receded enough to allow some travel exchange to start again. So,
right.
So listen, thank you very much. I really appreciate your time. I know this is incredibly busy legislative season. So it's I'd also like to thank you for your work writ large.
Thank you. Any questions for Peter? Do you know when the Tottori delegation comes to visit Vermont?
That's a good question. It'll probably be in July. Our, the agreement was signed on July 18th, 2018. So we're targeting that. Tim Tierney in Commerce and Community Development is working with them on this. They will, I think he asked that they give us about a 2-month lead time with a concrete schedule. But I think that's, late August is, Hirai Chiji means governor in Japanese. Hirai will target, he wants to participate. He's back up a little. He is the chair of the Japanese Governors Association. So he is interested in timing the visit around our national governors summer meeting in the United States. So it's kind of a long-winded answer to your question, but that's where it is right now.
So that's in August? That's in August?
I'm not sure whether they've set, the last time I looked, the national governors hadn't set the date yet, but they maybe have by now. So it'd be late July, early August, something like that.
Well, when we pass the bill and the first good news makes it before, we have to wait for the House, obviously, but you can share that news and get us back the information about when, and that probably will be helpful when the House deliberates.
Yeah, there's
if this bill, which we hope it will, we would love to be included and come and if we're able to participate, it would be interesting to have an economic development discussion as a piece of it.
Absolutely.
Absolutely.
Yeah. Hi, we haven't met. I'm in Brattleboro, and I actually went on a trip with a bunch of city managers to Russia, which is not what I really want to talk about, except that I was looking at the composition that we're proposing for the board, and I was thinking we might want to have more members, so I'd like an opinion on that, or I'd like to have a discussion on that. I'm a little bit familiar with what SIT does in Brattleboro, but not familiar enough to represent them. But particularly on page 2, E, which a member appointed by the governor with expertise in international arts or recreation. And the recreation just kind of caught my ear because I was actually thinking government, based on my experience, and now hearing that there actually is an interest in the governor conference. I think that's
So
something.
local government.
Or just governance.
Government in general.
Okay.
Governance, I was thinking.
Okay, because there's international relations about.
Yeah, but international relations is a little different.
Right.
Well, just.
I wouldn't dilute the arts
I know,
or
we could always
recreation.
add
I'd add a
a government.
I'd add a member of local government.
Sure, I mean, I would like.
But will you
there's a
take that
lot-
to David Hall and
Sure.
present an?
Yeah, and I was just gonna say governance in general, so it could be local, it could be statewide, I mean.
I had lots of
And
Russians come through Montpelier. Well, after Glasnost, there was a lot
Right.
of exchange.
Right.
I had a lot come through trying to understand how we ran local government.
Right, well, and planning, I mean,
Yeah,
just the
right.
way that.
Planning and
that
zoning is also
Development happens.
Yeah,
So.
so we don't have a lot of time
No.
tomorrow, so I would say it's not a hard bill to walk through oneself. If people who have an interest, if you could walk through and go to David this afternoon for any changes you want to propose tomorrow.
Okay, so that'll include more members also.
Yeah,
Okay, thank
I'm
you.
very open to whatever
Great.
change. I don't think they'll be controversial.
Okay.
Thanks so much, Peter. Thank you for your time.
Thank you. We appreciate it. And we'll
Okay.
we'll let you
where are
know
you
when
in
this,
academic?
we'll let you know when summer activities get scheduled.
Right, that'll be good.
Tim actually suggested, Tim Tierney, that maybe if this does get through both the House and Senate this year, that we ask Governor Scott to sign it when they're here as part of the celebration.
It's sadly,
Too late.
it would
Yeah.
be too late.
But we will
Would
do
it?
some
Okay.
other ceremony.
All right.
You
Yeah,
know,
no, definitely, we'll celebrate somehow. All right.
We don't,
Thank
we
you
don't
very
need a
much.
signing to-
All right.
Thanks, Peter. We're
Bye-bye.
waiting for Becky on Safe, so we're gonna switch gears to David, very fluid. Dave Bohr, thank you. If you're still with us, thanks for your patience. I would still like to try and get to you today. Otherwise, we'll give you the opportunity to address anything you heard tomorrow, and hopefully Julio will be here too. So any final questions can be answered tomorrow. But David.
Yeah, thank you. David Wickenberg here on behalf of Working Vermont. Just to briefly comment on the new draft of 102. Also, I should just say, I don't really know what this bill is, but I went on a trip to Yaroslavl as part of the Burlington High School Exchange, and also had and I had the delicious cuisine of fish aspic, which if you've ever had aspic, it's not something.
So it's like
It was
Icelandic.
not, it's salty jelly with fish in it, and it was.
My
You might like it
son used
now.
to refer
Yeah.
to the food they ate as fish food.
Yeah, it was tough, but it was a great experience, so.
Interesting.
So and I'm just gonna let the treasurer's office know, we're on hold until Becky gets here, and but you should still sit down, I would think, because it could be any minute.
I'll be very brief. I know you have a lot going on. We're supportive of the current draft of S-102. Obviously, like others, disappointed about the just cause termination. I think that's an issue that I hope that I've heard that we will revisit and look at and certainly talk about it in the House when this bill hopefully gets over to them. So, but just a couple of the clarifications in the remaining portions. Last time I testified, I had focused on the captive audience piece, and now that provision is now in 3 bills: a bill by the President Pro Tem and a bill by Senator Renner put forward, and this bill. And I think it's an important part of the bill that should remain. And just for some context, there's a report from the Economic Policy Institute that talks about this issue specifically, and I'm happy to forward it to the committee for your review. But some of the statistics, and I think Katie from Senator Sanders' office started to cite some of these, in terms of employers' involvement in union elections. I'll just cite from this: 57% of employers have threatened to shut down all or part of their facilities. 1/3 of employers fire workers for union activity during NLRB certification campaigns. 47% threaten to cut wages or benefits. 28% attempt to infiltrate the organizing committee. 14% use surveillance. 22% offer bribes and special favors. And the most important one, for your purposes for this provision, 89% of employers require their workers to attend captive audience meetings during work hours. And just so you know, I think there had been some question yesterday, is this a problem in Vermont? We know that that there are specialized, and I think you heard from Senator Sanders' office that there are specialized law firms and management consultants that partner with, that are paid to come in and work with businesses to run these types of campaigns. So I think it's a really important part of that legislation, and I hope that it remains in the bill and continues.
Senator Brock.
I just wonder if you could provide us with the source of the statistics.
Yeah, sure. It's a report from the Equal Economic Policy Institute.
Okay,
I'm happy to forward this.
Yeah.
And those are national, right?
Yeah, this is national. They
The
did
numbers are a little
national.
different than maybe several reports, but I've looked at another report by the economic same
Policy.
organization.
Yeah, yeah, I'm happy to send it over. So, yeah.
Are people left with lingering questions about S102 while we have David? That you think you might, scenarios or
No, not questions, but
concerns?
we may have some, well, I think what got brought up yesterday was the Federal Labor Relations Act that said that employers had a right. And so how do you balance the employer's right to express their feelings about unions or unionizing and the employee's right not to be browbeaten and threatened? And because when you were organizing against US Steel or General Motors, it was a big corporation. When you're organizing again, you know, in your local hospital, that's another scenario that we are also putting pressure on. And I just want to make sure that everybody gets, because it's not going to help the folks that unionize if half of them do lose their jobs. I mean, and
Yeah.
and it,
Well,
when you're in
that's
this-
another
when-
whole subject is
Yes.
what in Vermont have we noticed that?
Well, I think,
people
you know, we
lost
are into organizing much smaller groups that don't have corporate wealth like the traditional big business. And I'm not sure, there's some balance there. It's changing.
Yeah.
And I would say to that, I mean, employers, yes, have their right to express their opinions. They don't, what this bill would prevent them is forcing employees to go to a meeting and then threaten or discipline.
Right.
If they don't.
If they don't,
Yeah.
right.
So that's where.
So if people are genuinely curious about the pros and cons and think it's a source of helpful information, they can still go and the employer can be heard.
Yeah.
We don't ban the meetings, which some have maybe encouraged us to look at, but you just say the meeting can't be mandatory.
Right.
Thank you all.
Thank you, yeah.
I guess
No, I
one of the
appreciate
things
that.
that concerns me particularly is the card check provision. And it's, you know, part of my view is looking at it as if it were a political election, which in many ways it is, it's an election. And to have an election in a normal political environment in which you have one of the candidates' representatives in the voting booth with you when you decide, which you do in a card check situation, as opposed to in effect, a free and fair election where both sides have the ability to have their views presented to the voter, and the voter then decides on a fully informed basis, as opposed to the potential of being solely solicited by one side of the argument and then voting. And we've certainly seen these cases in which you've had, in fact, there may be one, in fact, quoted in that particular article that you referred to, because I know I read it again the other day, in which something like 80% of the employees indicated in a card check that they would be ready to sign up and so on, but when the actual election was held, it went the other way. And those are not unprecedented to see that happen. And I just believe that I have a feeling that card check has the ability to present one side of the argument without the other side having a clear opportunity to present its side of the case to the employee as well. And that's a concern for me.
I mean, I see.
I'm gonna put Becky right in the witness chair when she gets here, but keep going as long as
Yeah,
she's.
I'll get up as the second.
Yeah.
I appreciate what you're saying. I think there is, but I do think that card check is really a procedural issue, as opposed to an opportunity, not giving both sides and presuming that the two sides are the employer and the employee side. I don't, it's really a question of procedurally, are the procedures that are in place now a real detriment to folks being able to express their will and desire to unionize? And so, I mean, I appreciate your concern. I just see it more as a procedural issue rather than a substantive issue of, who gets to have the employer will have their voice heard in that process, and they do regularly. So.
Well, I mean, there certainly have been instances in which card check has come effectively as a surprise to the employer. I know it's rare, but it does happen.
Yeah, I'm not familiar with those, but yeah. I mean, particularly in Vermont and small, I imagine in smaller employers that nothing is a surprise about anything for small employers.
Well, we don't have card check yet in Vermont, so.
No.
You mean elsewhere in the country?
Yeah.
Elsewhere.
So, great.
Thank you
so much.
Thanks,
All right.
David. So while we're waiting for Becky, at least we have the treasurer's office here. I'm starting to look at the changes that were made. Yay, that's perfect timing. We have the draft in our hands, and the first highlighted instance is page 7. So I thought we'd start there unless you'd like to start somewhere else. I know.
To shift my brain.
Yeah, take your breath.
Okay, so Becky Wasserman, Legislative Council.
Some of us are really appreciating all the issues she's been dealing with in the last 24 hours. Right, Gavin?
Oh, this should
And
say.
Yeah, I just
This
noticed.
is a mistake though. It should
Okay.
say by not less than 1%. I'm sorry.
Okay, I was like, okay.
I will make that change.
Okay.
By not less than.
And so you guys, there's that more is.
Yeah.
Mhm.
But
By not less than which.
Then 1%.
less by not less. Okay.
Than 1%.
So their contribution can be between 1% and 8%.
Yes. I will make that.
Okay.
change. The next change is on page 12 with respect to the fees. So this has added language that, so the treasurer may require that each participant be charged a fee for program costs. And then the amount of the fee is determined by the treasurer, but the fee shall not exceed $30 per participant in each calendar year.
Pause for, I missed the conversation about this. So
It just said that the treasurer could establish fees and that we didn't have any, not what to exceed. I mean, that gives the treasurer carte blanche.
Right.
So as much as we love our treasurer, it does seem like that was a little
There
bit of
should be some.
Okay.
So, and you two, this was a suggestion from Gavin and Ashlyn?
Gavin was for the record. Yes, it was.
Okay, so this amount meets your needs on the upper range and nobody has a problem with that.
I just have a question. Does using the word defray mean anything other than like cover? I mean, is there any implication to it? Okay.
Probably, well, it's defined differently than if it covered it. Sometimes we say the fee has to cover the cost. So defray is just accepting
Like
that it might not
offset.
cover the full.
Yeah. Okay.
And in all fairness, a program for people who have less, not where you want to put the entire burden. of
No,
paying for
I'm
it.
fine with that. I just didn't know if it meant something other than offset or cover. It does mean something other than cover.
Exactly.
Yeah.
Okay. Thank you.
And just to add, I think we will still, $30 is just the most that any other state
Exactly.
charges. And
Oh, okay.
we fully anticipate and will
try to keep that fee as low as we possibly can.
That's valuable to know where the number comes from for the floor.
Yes.
Thank you. Okay.
Okay, and then the last change, two changes are on page 20. So the first is section 538 under accounting and reports. So this is adding in the House committees on Commerce and Economic Development and the Senate, this committee to be receiving the report that the treasurer will be submitting every year.
Right.
And then in section 2, the changes are just to fix an error. It should clarify that all covered employers with 25 or more employees have to offer the program.
Okay,
good. I can change this. I've just changed it to version 1.3
Amazing.
and send it to Scott.
That would be
if you wanna
great.
Vote on it.
Yes.
One thing I have not raised, but is in the back of my mind is audit. And I'm assuming, and again, the treasurer's office may well have looked at this, that this is simply another activity of the state that falls under the same audit requirements of auditing the state's books. But I'm wondering, have you had any conversation with the state auditor at all as to whether any of this is in effect outside of his purview?
Not that I am aware of, but we can certainly have that conversation.
It's a really important piece that I should have raised earlier.
Are you okay
I-
with voting?
I think it's okay,
Okay.
but, and if it's not, it can be fixed in the
Yeah,
house.
right.
But I think it's something that ought to be raised.
Wait, where?
And it ought to be part of the
It ought to be,
audit.
it's
Let's
part
just
of
say
the,
that.
yeah, it's the same paragraph that we're dealing with, section 538, auditing accounting and reports.
Mhm.
I think it's where it would be, if there's anything additional to be added, and it may not be necessary to add anything if it's considered in effect part of the same audit that would be done, but of the books and records of state. But I do have a question in my mind. We're talking about the audit of the program. We're not necessarily talking about the underlying audit of every account in it.
So
Right, I think we would be comfortable with including language in that section that, you know, to the effect that either, I suppose one option would be to just, you know, we can give the report to the auditor as well, and then the auditor could decide to
whether to
go further.
Well, you could add a paragraph, something that essentially says that this is subject to such audits as the auditor of accounts believes are appropriate or finds necessary or appropriate under audit conducted under generally accepted government
Yeah, I don't think we
standards.
have any issue with that at all, and I think it's a good, appreciate you raising it.
So Senator Brock, you could either offer it as an amendment on the floor, a friendly amendment.
I can do that, yeah. I can do that, and I can check the auditor's office to make sure there's language they're comfortable with, if it's necessary at all. I'm not sure that it is.
Yeah.
Okay.
But I think that's just a loop that we want to
Yeah,
close.
great.
Thank you.
So we won't try to add that now, but we do have the new draft with the, not less
with
than
the one
1%.
change.
Yeah, with one change,
Do
I've
people need
taken
to
out
see
the
it
highlighting.
before we vote, or they're
Nope,
pretty
I've written it in.
trusting?
We probably have.
Okay, what's nice is if we vote it up now, the day we take it up is the day of the press conference, so it's, you know, aligned with helping Vermonters understand for the first time what is being proposed, which will have an impact.
And this doesn't have a bill number yet,
Oh.
does it?
It will because it
will
has a
Oh,
committee.
that's right, it's a committee bill.
Yeah, well, what I'm thinking of is in terms of getting it to the auditor. If
They
we
can see
have-
the draft on our website.
Yeah, if we have a draft with all the changes made that I can forward to.
That should be.
I just sent it to Scott.
Okay.
so-
Be
All right.
draft 1.3 and it's on the website.
So are people ready to vote?
Yeah.
Clark, are we ready to vote?
Yes, someone needs to move it.
I would move that we vote out draft 1.3 of our committee bill on Vermont Saves favorably.
Any discussion? We'll take a vote. I know you might have to
Do we need
go.
the second?
Yeah.
Do you want a second?
Yeah.
Do we second?
You
that?
don't need a second.
Oh.
We covered. Yeah.
Okay. I'm sorry, now it's me.
Yeah.
It's the second.
Senator Brock,
Yes.
Senator Clarkson,
Yes.
Senator Cummings,
Yes.
Senator Harrison, yes. Senator Rum Hinsdale.
Yes. Hooray. Senator Brock, I wondered if you would report this one.
Okay.
Nice to have a unanimous one during crossover week that you can report.
There'll be a couple unanimous ones.
Well, the Sisters Fate, hopefully too, yeah. Great, so, and then, you know, Scott will help you with all the materials to get it in today, and if it's in today, then it'll be up on Tuesday, which is nice timing.
Okay.
Great. Thank you, Treasurer's Office. We have 15 minutes now, and if you are still out there in the universe, I'd love to give you these 15 minutes, and thank you for being a bookend. You started with us right at 8 a.m. You're still here, and we deeply
could be for legislators.
Appreciate it. And it's kind of an open time to try and answer any loose ends. I think Julio really helped too. But, you know, certainly want to, if you heard anything you want to address now, and then we'll open it up for questions.
So we're pivoting back to 103.
Yes, that's right.
Is that right?
Mm-hmm.
Okay.
Thank you. Thank you so much for having me back. And I do generally, knowing how the legislators work, try to keep my schedule flexible Tuesdays through Fridays. But I very much appreciate having the opportunity to respond to some of the witnesses' testimony earlier. I want to address Bor Yang, for the record, Executive Director of the Vermont Human Rights Commission. I want to address this concern about potentially opening the floodgates to lawsuits or subjecting employers to frivolous claims. And first, in terms of the no rehire clauses, the don't darken my door clauses, I just want to remind us all that we have the benefit of having already done this. In 2018, this committee and this legislature passed this provision as to sexual harassment claims. So it's been 5 years, and the fear that women who were sexually harassed would suddenly turn around and reapply for work and then immediately sue their employers just did not come to fruition. The only question that remains is, why are victims of sexual harassment protected under our laws, but not women who face other forms of discrimination or victims of racial or gender identity harassment? We have seen the state use this provision to bar really good employees simply as a bargaining chip to pay them less damages in a settlement. They were not doing this, using these no rehire clauses to get rid of bad employees. It was to pay someone less. And a couple of years ago, some of you senators who were in this committee may have heard the story of Ismina Francois, who testified before your committee and told the story of how she had experienced racial harassment at the hospital, hearing the N-word frequently, daily, weekly. And she was a good employee. She was good at her job. And she said that these no rehire clauses was used simply to pay her less damages. She stayed at that job. She just took less money. And so it isn't so much that employers are using these no rehire clauses as a way to get rid of bad employees or be done with people who don't have meritorious claims. She had a meritorious claim, and it was used as a bargaining chip against her. And we have to stop allowing employers to do that. Julio testified this morning, and so I'm going to shift to severe and pervasive a little bit. Julio testified this morning that when New York eliminated the severe or pervasive standard, it did not significantly impact the number of cases in New York. And the reason for that is that it's really hard to prove in a harassment case. First, you have to show that bad behavior was because of your membership in a protected class. We do a lot of intakes at the Human Rights Commission where neighbors hurt and harm each other, where store managers make derogatory statements to members of the public that get really close to harassment, but doesn't meet that threshold because they can't show that it occurred because of their membership in a protected class. So imagine one employee at work who is, let's say, Black, and he works in an environment with all white males, not unusual in Vermont. And let's say he is routinely the butt of jokes. People push and shove him around. The case is not even getting in the door, and our threshold is low to open an investigation. but it's not going to get in the door even for an investigation at the Human Rights Commission because there's nothing to suggest it is because of his race. It's bad behavior in the workplace, but it's not because necessarily of his race. Even if some of us in this room or he might believe that it is racially motivated. The other bar to harassment cases is something that Julio mentioned, which is that to succeed, a plaintiff has to show that their employer knew about the harassment and failed to take action. So not only must a plaintiff prove that the harassment is because of their protected class membership and their employer knew and failed to take action, they have to also show that the harassment is severe or pervasive. All S103 does is fix that one element around severe or pervasive of a claim that requires multiple elements be proven. This is why states that have eliminated severe or pervasive do not see the significant uptick in lawsuits. What you will do when you fix the severe or pervasive standard is that you are going to correct court precedents that I mentioned, where there were these really meritorious cases, and those are going to finally get their day in court. We don't know if they will prevail, but they will get to the jury. And that's our goal. And we want our judges and the people of Vermont to hear those cases and decide for themselves whether or not those rise to the level of harassment in the workplaces or in places of public accommodations. And I think Senator.
Oh, could we pause on that statement? Because I think a question came up on that.
Yes, please.
Senator Brown.
I'm, again, I just wonder if you could refresh my memory of states that have made this kind of change that are being proposed here. How many, which ones, and what are the results? I know I've seen here that New York has done it, but has basically no cases at this point. Are there any cases where a change like this has been made elsewhere, and what's been the result?
Yeah, Washington did it, Delaware did it, California fixed it. So California, Delaware, Washington, New York. And even there are bills to change this on a federal level, and also bills in Virginia and bills in other states as well. So yes, we have seen states correct the severe or pervasive standard, and we've seen states eliminate it altogether. And I just want to go back and say that the fixing a severe harassment doesn't make it easier to prove that harassment is because of someone's membership in a protected class. And just because someone meets the definition of severe harassment doesn't mean that they can sue their employers, because they still have to prove that their employer knew and didn't do anything. And that's a hard standard. There are many instances at the Human Rights Commission where there was harassment. You could show that the harassment was because of someone's membership in a protected class, but the state agencies and departments immediately took action. They investigated, they fired somebody, and you don't get to a determination that discrimination has occurred. Because when an employer knows something and it addresses it immediately, they're not liable. And I think that's I think what you're just trying to capture are the instances in which employers are not addressing something, and we know it is harassment because they can prove that it's because of their membership in a protected class, and we're trying to address this severe or pervasive, where we have courts saying, you know, even courts deciding that sometimes 1 or 2 instances are enough, other courts deciding that 16 instances is not enough. Right. And us setting a standard in Vermont in our statute that says we got to start looking at this differently and create a clear statute that defines what harassment looks like in the state. You had a witness, I think her name was Megan Sullivan. She mentioned a service animal issue in a restaurant, and I just want to quickly address that. It is already law that places of public accommodations have to accept service animals. There are only a few exceptions to that. typically when health and hazard issues, like in a kitchen of a restaurant or in an operating room at a hospital or any kind of place where the business could argue that this would pose a hazard to safety, they have to permit a service animal. So that's already law. S103 doesn't change that. It's not going to bring more lawsuits because people don't know the law. In fact, what usually happens is, and what we find is that restaurants and business owners don't know the law. But that's not and that is why they reject service animals. That is not a basis to not move this bill forward because they are ignorant of the law. We know that ignorance of the law is not a defense. And, you know, for what it's worth, you all supported in S100 adding a position to the Human Rights Commission for a full-time litigator. That's going to open up resources at the HRC to do more outreach, to these places of public accommodations. We do free trainings all of the time. We are available to do those if we have the resources and the time. And so I would love to teach what a new standard for harassment looks like. So I hope I have answered the questions that have come up, and I have tried my best to address the issues that other previous witnesses have brought up. I'm happy to answer any questions, any additional questions you have.
Can you address this idea that diversity and equity trainings might be political and unable to occur? Did you hear that part, or do you want me to
say that part again? Yes, thank you.
Allison, do you want to explain? I think I missed the first time it came up.
Yeah, it was raised by the chamber that that possibly diversity, equity, and inclusion training would be considered a political, that it would be a political act to require this kind of training, and that therefore is in the captive. I think this came up in 102, not in 103, but it came in up as an issue in terms of the captive audience.
Oh yeah, sorry. Two bills are now like merged.
Right. Yeah. Let me say this, is that the trainings that we are talking about are compliance training. This is the law. This is what you have to do. Sort of like sexual harassment training. And that is not political. It's basically when we do our fair housing training, which takes 4 hours, on the second Mondays of the month, the training is for landlords to help them comply with the law. Do we try to incorporate in that training the necessity of understanding why people with disabilities need housing? Or do we try to have a conversation in that training about how national origin and race discrimination in housing is still very prevalent after all these years? Yeah, we do. But for the most part, the training is really about compliance. There is a lot of controversy right now around different types of diversity and equity training.
And the big question is, should we just add a line? Like, should we work with you before we vote tomorrow to make sure it's clear those are not, they're not in the definition, but
well, yeah. If board's doing training for landlords, do you have the legal power to compel landlords to come do the training? Or can they just say, no way, which is different from your employer requiring you? And I don't think I need to tell you that some of the equity training right now is highly controversial, at least in the school setting. And I guess I can see where some people would, where some people would say it's not compliance with the law per se, this is what this school's policy is going to be, or this is what, I don't know.
Okay. I can speak to our training, which is Both, we do trainings on implicit bias. You senators have taken that. We do trainings on microaggressions and bystander intervention. We do trainings on compliance with the law. They're all voluntary, except when we reach a settlement agreement.
To attend.
Except when we reach a, no, let me clarify. Except when we reach a settlement agreement where the parties themselves, when a tenant might ask a landlord to agree to doing training, and the Department of Housing and Urban Development says they would like landlords to take those trainings. And it is true, and so they agree to it. They sign off on doing it. So you might say, oh, well, they had to, but we're not forcing them to, and they certainly don't have to take it with us, but they reach the agreement on them by themselves and on their own. And sometimes I often find that even when they're there because of an agreement and not voluntarily, they always appreciate it. We have a lot of landlords, we have a lot of business owners in the state of Vermont who don't know the law because they're not big businesses or they don't have lawyers or legal counsel on staff. So when they come to our trainings, they always appreciate knowing about the law. And so no, we don't have an issue with forcing anybody, and because we don't. And also, they always appreciate it.
That's not the issue. But that's not the issue. The board is not their employer. If your employer says you have to go to equity training, and I find that equity is against my religious principles.
Okay.
You can handle that? Okay.
Do you mind if Julio jumps in more?
Oh, please do. Yeah.
Mike, would you like?
Sure, yeah, or from the side.
It's more comfortable.
Yeah.
Hi, Julio Thompson, Attorney General's Office, Civil Rights Unit. Well before this legislation, well before anything called DEI training, employers have for a long time provided training for their employees about what the law is dealing with discrimination are. Now, taken at the most literal sense, every law that's passed is a political act. Elected officials pass laws. And so there are employees, for example, with the Department of Motor Vehicles that get training on things like not being an accessory to identity theft.
Right.
And talking about how the feds will catch you if you do that. And they usually have videos of very sad employees who've been convicted and made plea agreements, and they do these kind of hostage videos where they talk about what a big mistake it was.
Or like sexual harassment, right? I mean,
right. So
you
take it
can't
at the
say
most,
that's against your religion.
take it at the most literal level.
No, it's equity that's causing all the trouble.
Yeah.
Well, but still, it's just.
At the most literal level, like anytime you train someone to comply with the law, you're referring to a political act. And so, and that hasn't never been viewed as compelled association or compelled speech. So an employee can be sanctioned for, subjecting other coworkers to anti-Semitic viewpoints, even though that might be consistent with their religious viewpoint. The law doesn't allow you to do that. The First Amendment allows you to worship, to do that, but not to
proselytize.
And not to interfere with someone to be able to do their work. So I think.
What if someone invites you to the Christmas party, the work Christmas party outside of hours?
If you're invited in, you don't have to go.
Okay.
Yeah, it's a voluntary thing.
Yeah. So there's no like, we missed you at the Christmas party, now you don't get a raise or a.
Yeah, I mean, if there were evidence that you were viewed as you didn't go because you don't share my religious viewpoint, that would be a form of discrimination. But training people about the law, and there could be good training and bad training. You can have terrible training on avoiding identity theft that could talk about the moral wrongness or that may be far afield of the law, but if the fundamental purpose of the training is to train someone to comply with the law, that's often it's certainly permitted and often encouraged and sometimes required depending on what the laws are.
It's not compelled speech. It's not what was the
it's
term
compelled.
used?
It's compelled attendance.
Yeah, and in the workplace, understand with compelled speech, workplace rights they're not the same as you have on the sidewalk. So the Attorney General tells me to come here on Act, it's compelled speech because I have to testify.
Right.
Employers can direct employees to carry out their job, and that might include speaking on behalf of the employer. And that's different than discriminating against people because they have a different viewpoint.
No, but this specific one is if an employer that requires you to do equity training, okay? Not necessarily compliance with the law, but what their version of equity training is, could that be considered compelled political meetings? Not, this is the law, just this is what I think equity should be, and this is what it's going to be in this building.
I guess the answer to that is it would very much depend upon what the equity training was. If the employer is training someone that you should vote for a law that advances some objective, then that might be in a political vein. But if it's talking about fair, there are principles that we talk about how we work together, like treat everybody equal, that are also embedded in our Constitution. That doesn't make it forced political speech. And so it would have to really be addressed on a case-by-case basis, because not all trainings are alike. That's the most I think you could say.
And Damien has his hand up, so we have 3 lawyers at our disposal to answer these questions.
So far, you're saying
If we didn't work for the state. I wanted to just address that, the concern about political matters. It's important to refer to the definition in the bill, because just because you think equal employment opportunity is a political issue, that this talks about matters relating to elections for political office, political parties, legislative proposals, proposals to change rules or regulations, and then the decision to join or support a political, civic, community, fraternal, or labor organization. So it doesn't speak to compliance with the law, which is what a diversity, equity, and inclusion training is usually related to. And I also think the issue is raised around in Florida, employers sued the state over what Governor DeSantis refers to as the Stop Woke Act, which what it basically said is it dubbed as an unlawful employment practice, including any mandatory, or it included in the definition of unlawful employment practices, mandatory employer training based on race, color, sex, or national origin. Including requiring employees to attend training that espouses, promotes, advances, inculcates, or compels any of 8 concepts. And then the concepts were worded very, very broadly. And employers sued on the idea that the concepts there outlawing those amounted to viewpoint discrimination. So the idea that teaching that some of the concepts that are in diversity, equity, or inclusion would be a particular viewpoint, and that they were forbidding that viewpoint. And that's what the court ruled against there. And what they enjoined was what they saw as viewpoint discrimination. And I'm doing a very bad summary of this because I know we're 9 minutes into your lunch break. But so it's a little bit different than what we've got in front of us. The court was concerned that it was overly broad, and that it impermissibly prohibited or impermissibly regulated viewpoint speech there that employers would include in these trainings, and that it was so vague that employers couldn't determine what was actually prohibited, and so they were raising the risk of being sued under the law for expressing concepts related to diversity, equity, and inclusion. in their training. And this is different than the case in Connecticut, which is ongoing, where the argument is that it restrains the employer's ability to speak freely by allowing employees to not attend the meeting. And that gets more into the First Amendment section at the beginning of the bill, which Connecticut has, which some of the advocates have said that they're not sure the bill needs. So that's another piece there. And that Connecticut case is currently at the summary judgment stage, and the court's gotten the motions from the parties, but there's no ruling yet. So we don't know how it's going to come out there at this point. But that there's sort of two separate issues, and I just wanted to make sure we broke that out, because the issue of training on things related to anti-discrimination law is a little bit different from what the bill says, which is promoting a political candidate or party, or an organization, including a labor organization, which that gets into another area that I can talk about tomorrow when you have more time.
Yeah, great. Oh my gosh. Thank you. Thank you, everyone. Before we go off live, I just want to preview quickly for tomorrow. We are going to start at 9 because people can't start before 9. But that does mean that, I really want to get to the S-100 amendment. We should, all be aware of what's in it and be able to offer our vote on the amendment before when it goes to a probe. So that would mean possibly eating into the first half hour of lunch. So I just want to, and we have to go to the floor, so it's going to be a difficult dance, but I'd really like us to have time to consider that. What that means is I've heard a couple areas where we might have little tweaks or amendments that to consider and propose. I might look at those further this afternoon and see about an amendment myself on any of these. I don't have anything concrete right now. We heard about this first, the free speech piece. We've heard about, should we move labor to its own section or whatever and have that discussion separately. But if you have amendments to any of these, just please have them drafted for tomorrow so we can consider concrete language changes before tomorrow. Otherwise, we're going to go section by section and mostly just say up or down. And, anyone can propose an amendment at that time.
Do we have the S-100 language?
Scott can get it.
Please, that would be really helpful.
Scott can get it. Yeah, it exists on the SNRE website, and we'll just pull it. Do you want it emailed?
Please.
Yeah,
Okay,
or stuff like that, a hard copy is actually easier if we're going to look at it and do something this afternoon.
So you can keep it on your, Scott will do hard copies and email, and the hard copies will be here for tomorrow or for today.
That's fine.
Okay,
Email.
perfect.
Thank you.
Thank
Thank
you.
you.
Anything you need to add for today? Okay. Thanks, everybody. So we'll go off live. Tomorrow's a big day.
Yeah.